a lot of disposals yesterday, and those were all bail orders. Few could not be, wasn't ready yesterday, so I had to sign it. Sorry.
May I please, your lordship. Lordship, therefore listing an AV, lordship, can it be day after tomorrow, lordship, one AV?
AB,
Special act, lordship.
special act.
Published.
Call for.
May it please your lordship, I beg to mention item number 25, lordship. My senior Mr. A. Biswas is out of station, lordship. Already a leave
As prayed for by Mr.
PK Basu,
Have you informed the other side?
lordship.
Inform and come.
Lordship,
Please don't make a mention before this court without taking consent from the other
lordship,
side.
other side had informed me not
Mr.
appeared,
D. Goswami, Mr. N.K. Kashyap, Mr. J. Kalita.
I have not informed them.
Then
But private
Please
responsibility-
don't waste the judicial time of this court. Next.
May I please, Lord? I'd like to mention item number 11, my lord. They file a additional affidavit regarding from documents.
Alpha,
Yes, my lord. Any other date, my lord.
you want it on another date? Item number 11.
Item 11, my lord.
I'm appearing for the informant. Your
As prayed for by Mr.
Yeah, made.
A. Ahmed, Learned Counsel, for the petitioner relist on after a week on a date to be fixed by the registry.
Oblige, your lordship.
Yes,
Can I pray for listing lordship for 14th of May
listing what?
for admission?
What?
First appeal lordship.
First RFA.
Yes, lordship.
Item number.
Yes, Mr. Abdullah.
Please, your lordship. Here, my lord,
NDPS.
NDPS number 21A, your lordship. Lordship knows it's a bailable section. And in a bailable section, my lord.
Yes, call for
One, my lord,
Lordship on
my lord, may I-
CD.
CD,
Call for CD list on
Lordship on 9th.
my lord,
on
may I
9th.
place one judgment of latest judgment?
on 9th.
Oblige, your lordship.
CD or scan copy.
This is scan copy Lordship.
Call for the scan copy from the court of
Additional session judge.
additional session judge,
Bhumi.
huh?
Bhumi.
Sri Bhumi, through the call for the case records from so and so in connection with special NDPS case number 102 of 2024 arising out of Karimganj PS case number 574 2024. To the registry of this court, list on such and such date.
Bail on arrest procedure. Date may be given, my lord.
It had 11. 9th.
Item number 3.
POXO,
No.
Lordship.
you have made the informant party.
Yes, lordship.
All right. Issue notice, steps in respect of respondent number 2 informant be taken within 3 days from today through the registry of this court in terms of the direction passed by the division bench of this court in the case of Deepak Nayak versus so and so in so and so. List after
15.
2 weeks on a date to be fixed by the registry. In the meantime, what's
CD need to be
huh?
15.
No.
CD need to be called.
CD. Mr. K.K. Das, Learned APP, shall produce the case diary of the case on the next date of listing.
15.
Huh?
It may be fixed.
All right.
Behind bars.
15. One
You see, the service has to be served. Yes. I've given you a date. POXO,
Lordship, there is a violation of the fundamental right of constitutional right.
whatever be it, POXO is there.
Yes, Lordship.
Yeah.
But Lordship, the statutory restriction.
You
Lordship,
should
cannot-
notice,
Lordship, one thing, Lordship, with all respect, Lordship, I may be allowed to submit. Lordship.
yes, please.
Lordship, as per the Bihankubar judgment, Lordship, where there is a violation of the fundamental right, the statutory restriction may not affect the power of the court to grant bail, Lordship.
Issue notice, list on,
Lordship.
no, don't say that. Steps in respect of respondent number 2.
Otherwise, Lordship,
Respondent
there-
number 2,
Respondent two, Lordship.
Respondent
There is
number
a-
two be taken through the registry of this court in terms of so and so that decision, huh? And
It
CD,
need to be called.
let these case diary be called for list on such and such date.
Thank you for
Mr. Counsel, you want this court to give you an order on the ground that your Article 2222 1 has been violated on the first day without going through the case diary?
Nine.
Certificate to be public submitted also. Nice. I'm of
Yes, Mr. Chaudhary,
Madam, this petition,
this is
everything was seized from other person, everything. I am neither owner of the truck nor anything. Simple. Last
where is
page,
the FIR
madam, page 10.
page?
Page 10, madam. It is a truck, some goods, madam, in a truck. That was page 10, madam. On 4/4/25, madam, second paragraph, your lordship.
Mhm.
On 4/4/25. your
Yes,
lordship.
let's
Yes,
read.
consign-
Let's read. You are Mr.
I am Mufajjal Huya. My name comes page 11, madam. Everything was seized from some other
Mufajjal,
person.
led by Mufajjal.
Mufajjal.
Mufajjal, right?
Mufajjal.
Let's just read. Let's see what is your role ascribed in the FIR.
Nothing, madam. Your loss kindly see, madam. 4/4/25 consignment, your loss may kindly see, madam.
Yes, yes. Mr. Chaudhary, the problem is you know the facts. I don't know it. If you are seeking for an anticipatory bail,
Yes, yes.
then I have to apply my
Exactly,
mind,
exactly,
right? That is why I am asking, please read the FIR.
Oh, I am.
Unless you read the FIR,
Yes. No, I thought your lordship
you
is-
cannot expect the court to
Well,
read the
that's-
files and come and give orders. Then we
Your
can do
lordship
so.
done, your lordship.
We can just read files
Yes.
and give it without hearing counsel.
Madam, 1/4/4/25, a consignment of Hindustan Unilever products was loaded at so and so Calcutta in a truck bearing registered number so and so. The consignment was destined for Sangsari Guwahati. Truck was being driven by Rufchan, village so and so holding driver number so and so, and is accompanied by one Inamul Hassan. As our tracking system, the vehicle crossed Siliguri on 5/5/4/25 and continued towards Guwahati. However, on 6/4/25, my head office in Kolkata informed me that both the drivers and the helpers' mobile phones had been switched off. Despite several attempts by me and the vehicle owner, their phones remained unreachable till late evening. Subsequent on 7/4/25, the truck was recovered by so and so outside Golpaka district, and they started examination of the drivers. During interrogation, they confessed to offloading the consignment on the road to Bhutan. Acting on this, a team from Siddhi PS followed the accused to the house of so and so Basumatari, located on
I
the.
think, Mr. Das, they can appear because the allegation against Mufazal is that the operation was led by him. That is the allegation, but it appears that the drivers and all have already been arrested. Let him appear. Perhaps that will help you. Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned APP for the state respondent. This is an application under section 482 of BNSS for granting pre-arrest bail to the petitioner, i.e. Mofazal Bhuiya, alias Mofazal Bhuiya, alias Mafazal Bhuiya. Please check at page 2, who is apprehending arrest in connection with Runikata PS case number 03/2025, registered under section 61(2), 3163, 3032, 317, 3174 of BNS. Call for the case diary fixing on
22 May.
22 May so and so. Considering the facts and circumstances of the case, it is provided that in the event of arrest, the petitioner named above shall be released on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees
30 Lordship.
30,000 with one surety of the like amount to the satisfaction of the arresting authority, subject of course to the following conditions. 1, 2, 3, list accordingly. 10 days.
Alright.
So he will appear on the
Obliged.
before the IO within 10 days, failing 11 day cancel.
Item 6.
May I please, your lordship?
Foxolo.
Your lordship can.
POXO, yes. Issue notice, call for CD.
Lordship.
Call for CD, steps in respect of steps for service of notice in respect of respondent number 2 be taken by the petitioner within a period within 3 days from today through the registry of this court in terms of so and so. List accordingly.
Your lordship, just one humble prayer, your lordship. This person concerning is a government employee. Can it be listed on 13th due to the
All right.
elections? Your
No
lordship?
problem. 13. 1, 3, na?
Indeed, your lordship.
7, cheating. Yes, let's see FIR.
Yes. Yes, your lordship. Your lordship, no FIR has been
Huh?
restarted as on today, your lordship. Only for apprehension of arrest, I am.
Why are you apprehending?
Your lordship, I am the.
You must have
proprietor
done
of Allied
something.
Security Services, lordship. But
Why are you
lordship, the
apprehending?
One GD entry has been registered against me, lordship, in view of the above, lordship. Police personnel has
Can you
visited
find out, Mr. Das?
to my house, lordship. And lordship,
When should I fix it?
On. Lordship, second May.
Let Mr. KK Das, Leonard APP for the state, apprise this court on the next date of listing as whether any FIR has been registered against the petitioner in connection with the GD entry.
GD entry, your lordship.
In connection with the GD entry.
54/25, your lordship.
Hmm?
54/25, lordship.
Where do I find it?
Your lordship.
Yes, GD entry number 54/25 dated 10/4/2025. Dispur Police Station GD entry, huh? In connection with Dispur Police Station GD entry, number 54/25 dated so and so.
I may be interim protection only because of that, your lordship. I was lordship remanded police
Next.
custodial lordship for a period of
Next,
24
a short date.
No count of arrest
Monday?
has been furnished to me, lordship.
Monday?
On
All right.
second, Lordship.
Huh?
No, second. On second, Lordship.
Your lordship.
Are you arrested?
No,
Are you arrested?
not been arrested.
Why are you saying no grounds of arrest has been given to you? Now you cannot
But
bring
lordship, police
article
personnel has
violation of
forced me
Article
to, lordship,
22
issue the said to the
1
authority
in
court,
all
lordship.
cases.
So lordship, for the period
next.
of overnight, lordship, I was stayed in police custody.
Monday, okay.
Lordship,
Monday.
deeply.
POXO.
My lord, notice may go.
POXO. Issue notice, call for case diary.
Lordship, case the
Steps, that same thing, huh? This is POXO. List on?
16.
Yes.
My lord, anticipatory will, can it be preponed, my lord, if possible?
Yes.
So it has been, notice has to also be
The
gone.
only problem is, you see, I don't
Yeah,
have
I
a
understand,
problem
my
in
lord. I
giving you a
understand.
date in the next week also, but
Yes,
that notice has to be
Notice has to
served.
My lord, my lord.
Ki this a date? 13 going down.
Much obliged, my lord.
Item number 20.
Yes.
26.
Yes.
I have received the instruction, Lordship. One case has been registered against Ronju, RONJ, and he.
Against the
NDPS case.
petitioner.
Lordship,
So a case has been registered.
registered.
Yes,
Case number is, Lordship, 35/25.
no,
Gomukh.
no, but what is
go-
the FIR? Where is the FIR? You have it?
No, I don't have the FIR, but it is registered under NDPS, Lordship, commercial quantity.
Then
20.
how can I entertain this AB?
I only through instruction, Lordship.
File this petition without any FIR, but
That's
we
correct.
take instruction that with telephonically that one case registered.
Correct.
Now he has to withdraw this case and file a fresh,
File-
correct.
yes, Lordship.
taking the FIR, my lord.
Yes, and it's an NDPS.
Case registered, case number, we have, my lord, 35.
So you are going to withdraw?
Lordship.
Uh,
Only one
Then we may be given a liberty to file. That's all right.
Yeah.
You are Mr.
R. Fukon, Lordship.
Jahi, in this case, there is an just have a look, don't you? Yes, your name?
R. Fukon.
Mr. R. Fukan, learned counsel for the petitioner, heard so and also KK Dasa, APP of the state. Mr. R. Fukan, learned counsel for the petitioner, submits that he may be allowed to withdraw the anticipatory bail application and with liberty to file fresh. Prayer is allowed. Anticipatory bail applications then dismissed on being withdrawn with liberty to file afresh.
Obliged.
RFA,
RFA, my lord. Let it be admitted, my lord.
first time.
First time.
Heard Mr. S. Ali, no,
A. Iqbal. A. Iqbal.
A. Iqbal, learned counsel for the appellant, stop. Admit. Notice will go to
8 respondents.
8 respondent. Notice notice as in term notice by registered post AD steps within a week from today, and anything else
LCR may be called.
let the TCR be called for through the registry of the court, list after 3 weeks
Madam.
on a date to be fixed by the registry.
Deeply obliged.
In bail on arrest procedure ground, my lord.
Arrest procedure.
Yes, my lord. I have flag marked in the LCR, my lord.
Hmm?
The notice and the arrest memo, I have flag marked in LCR.
Anything in the material to show that it was intimated? Nothing. Nothing. পিডিকা কি কৰিলে সেইটো কালিৰ এনডি When was he arrested?
15/10/2023.
15,
10/2023.
10,
2023. Yes.
Beginning, you right. Item 10. You are Mr.
HR Chaudhary.
Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned APP for the state respondent. Yeah. Copy two. This is an application under section 439 of the CRPC for granting regular bail to the petitioners in connection with special NDPS case number, petitioners, i.e. petitioners or petitioner? Petitioner, i.e. MD Kamrul Islam, who has been arrested on 15/10/2023 in connection with special NDPS case number 136/2023 pending in the court of Special Judge Karimganj arising out of Badarpur PS case number 284/2023. The facts of the case is FIR is at page?
FIR, my lord, page, it is page 11, 12, 13, 13.
13. Mr. Sharma, you have checked the scan copy properly?
Yes.
There is nothing on record to show that
No.
there is any contemporaneous record of intimation.
No, Lordship.
The brief facts, did you write that? Right? Is that one SIP Abhijit Gogoi, Badlarpur PS, lodged an FIR before the jurisdictional police station alleging inter alia that on 15/10/2023 at about 3:30 p.m. an information was received from reliable source that a large quantity of stock of illegal contraband articles is kept hidden by one. Is the petitioner?
Yes.
By the petitioner in his house and is going to deal the stock soon. Accordingly, after making an entry, a police team proceeded to the location, and after reaching there, they interrogated the petitioner, and he confessed during such interrogation that he deals and sells illegal psychotropic substances and that he has kept 2 numbers of carton boxes containing illegal cough syrup in a room of his house. It is further alleged that the petitioner led the police team to the room of his house, where from 2 numbers of carton boxes containing 219 numbers of bottles weighing approx 21,900 ml was recovered and seized. Accordingly, a case has been registered. Thereafter, a case was registered. Accordingly, the instant bail application stopped. Now, OP, this is the format. You just have to change his name. You're going to write it from here, huh? This get in bail application 2025. Your name?
HR Chaudhary.
Hmm?
My name HR Chaudhary.
HR Chaudhary.
Chaudhary.
HR Chaudhary. The same paragraph 4. Paragraph 5, you will put B Sharma instead of the name here. Okay, everything remains same. Paragraph 6 remains same. 7 remains same. 8 is also same. Now in 9,
They have also filed an additional affidavit. Proton report the.
so I was just
Yes.
trying to see the production order if there is anything. Because you see, even something comes out in the production order, that may also
Yes.
help. But nothing is there. When you, in para 9, the section note 50 notice has been quoted. You will get it at page. Understood? That quote portion is 50. Then para 10 remains the same. Next, the arrest memo is not there.
No, is there.
50.
Next is the arrest memo,
The
which
next
you'll
is-
get at page 52.
50.
Everything remains same. Inspection memo, you will get at page
Page
58.
51.
Next page.
Got it? So para 11, 12, accordingly, just change the quoted portion. 13 same, 14 same, 15 same, 50,000 and special judge,
Sri Bhumi.
Huh?
Sri Bhumi.
special judge Sri Bhumi.
One government surety, Lordship. One government surety.
Very poor person, madam. Government.
Required.
No, I provided that with two sureties of like amount, provided that one surety has to be a government servant to the satisfaction of the learned. That is the condition
Yes,
for
yes.
NDPS.
Yes, Lordship.
There cannot be any.
Lordship.
You'll get it here, no? Any more NDPS
Yes, sir.
violation of 22(2), then you are appearing? No, it will did 13.
Item number 12, my lord.
12. All right. Mr. Nat, all right, you wait. Let me finish Mr. Nat first. 12. Give me 12.
12.
Yes, APP,
NDPS.
who has gone through? Scan copy has come.
Lordship, CD is available.
It is available. Have you gone through? Same ground, Mr. Nat?
My lord, this is lordship's the judgment. I've seen that, my lord, the elaborate judgment. Well, if it's covered by that one, my lord, then record will say so.
So basically same ground, 22-1.
Yes.
Okay.
To do 47 notices, Lordship, kindly peruses in this.
C. This is under.
7 notice.
What is about, is this sufficient? Is investigation. Sufficient evidence collected against you for which you have been arrested. When charged against you falls under purview of so and so.
Contention is, Lordship, he should be made aware that he has been arrested.
All right, this will need some, Mr. Nat, you wait for your turn. It will need some
Yes.
deliberation. एक घंटे हम घुराई दियक, huh? Or not multiple, yes. Wherever there is an admittedly there, because you see then what happens, it is easy for the stenographer to type it out. That is why I wanted those matters to be called where there is an admitted violation of Article 22(1).
Is also violation.
Which one?
13, I think.
13 to Diok.
88.
13, same Mr. H.R. Chaudhary, okay? K.K. Das and undicted paragraphs. This is an application under section 483 of the BNSS 2023 for granting regular bail to the petitioner in connection with special NDPS case number 50 of 2022 pending in the court petitioner I, MD Najimuddin, okay, who was arrested on 25/3/2022 in connection with special NDPS case number 50 of 2022 pending in the court additional session judge Sri Bhumi arising out of Karimganj PS case number 2211/2022, yeah, under section registered under section 22C of the NDPS Act. And just brief facts of the case is that on 25/3/2022, the officer in charge of the of Karimganj police station received an FIR from the informant who is the in charge police official Kaliganj police station, Karimganj, to the effect that on 24/3/2022, the informant received an information that large quantity of narcotic drugs have been is going to be carried towards, shall be carried towards Kaliganj site by one drug peddler belonging to Kaliganj area, who was coming by a magic truck and was likely to deliver the consignment to other peddler on that date. Accordingly, a police team was sent to the spot, and after they reached, they apprehended the petitioner, and upon searching, narcotic drugs have been recovered from the possession of the petitioner, which were seized and handed over to the ASI Karimganj police station. Stop. Thereafter, a case was registered. Accordingly, the instant bail application. Mr. Same name, huh? Mr. H.R.A. Chaudhary, para 4.
R Chaudhary.
Huh?
HR Chaudhary.
HR, sorry. Para 5, KK Das. Para 6, para 7, same. Para 8, same. Para 9, in the earlier one, probably it did take some time. Genesis, it is 40. It is 47, then 47, okay? This para 9, the quoted portion, you will find at page 49. Who is Badul Islam? This 50 notice is sent to one Badul Islam. He's not the petitioner.
Not the petition. Azimuddin.
Huh?
Azimuddin.
No, Kamrul Islam.
Full Islam item 10, madam.
এখন কি দিছে? এখন ভুল দিছে ইয়াত। এখন BA 1919 আৰু এটো BA 7557 আৰু এখন আপনি ভুলকে থলে নেকি? Just one second. Where is the original one?
10 copies data.
You have filed 2 affidavits today.
No, madam.
Only one.
Madam, in both case, I have filed affidavit on 28, madam.
Where is the affidavit of this case?
There, madam, right.
Hey, OP, he has changed it, huh? So the page numbers could be different, but you will get that nearby pages only. I think this is 19. Earlier one was 191.
19, earlier one.
In that, the 50. Into Saipele Dibo. In the earlier one, the 50 notice is at page 49. Arrest memo is at page 50. And inspection memo is at page 51. Okay. Started over. Now in the present case, the 50 notice at page 57. Arrest memo at page 52. Inspection memo is at page 58. Okay. This takes care of your paragraph 9. 10 remains same, 11, 12 remains same, and 13. Thereafter, everything remains same. In para 15, 50,000 special judge,
Bhumi, madam.
Tribhumi. Both have been disposed of, huh? Look, disposed of. 4 to 10 asil na? Yes. Yes. You have a similar case?
Number 15.
Similar?
NDPS.
Huh?
NDPS.
So, in item 15, are you urging the same ground? Then why are you coming? Your matter is not called. Yes, Mr. Ahmed?
Item number 17, Lordship.
17, same ground?
Same ground, Lordship.
Is it correct?
So I think CD has not.
It is not received.
I'm having the original certified copies of
You show it to Mr. B. Sharma, we'll call it after some time. Yes, now call as per the list.
Right from the case diary, Lordship. So the case.
All right, let it call.
Yes.
Yes, Mr. Nat.
My lord.
Quickly, sound.
So far that notice is concerned, if I take a lordship's judgment to the. No, that could be the actually. Lordship, may take a lordship judgment, my lord.
See, if I've understood Vihan Kumar correctly, the arrestee must know for what he is been arrested.
Yes.
Correct.
Yes.
This is, I think, the
Right,
requirement.
because
Huh.
in section 50 of CRPC, very sentence, the heading kindly see, person arrested to be informed. What
Correct.
does it mean?
Correct.
It's not prior. It means once you arrest him, you inform him that I have arrested you. This is the ground to arrest you.
That's right.
what- And there's
So,
the explanation in paragraph
Basically,
22, my lord.
you see, that is under the statute. Now, as per the Article 22, one is also concerned.
Yes.
It says the person arrested must be informed of the ground of arrest immediately or as near, there is a word there, right?
Yes.
What is it? Just read it. As
My lord,
immediately or what is it written?
this is
Article-
section article.
Article 22(1).
Article. Lordship is quoted here. Just 1 minute, my lord.
Yes, I've got it. No person who is arrested shall be detained in custody without being informed as soon as may be
Yes.
of the grounds for such a. So what it means is that in the contemporaneous period of time, that is immediately near around,
Yes.
he has to be informed. That is why this court goes through the record to see whether
Yes.
it may not be on that same day, even on the next day also if it is done.
Permissible.
Article 22(1)
Yes.
is fulfilled.
Yes.
Right.
Permissible.
So that's the only reason this court goes through the record. Now, in your case, that is the only document, right, which shows that something was informed. It seems an entry is there, whether that is sufficient or not. Now, you have Vihan Kumar. Are you carrying Vihan Kumar?
No, I'm carrying your lordship that Kubeluddin.
I think Mr. Shekhar would be carrying Vihan Kumar. Please lend him a copy and you read paragraph 18.
Even in this judgment also.
We'll come.
Yes, my lord. Right.
This is a very, it's quite a topic right now,
Yes,
Mr.
yes,
Nath. So
yes.
let me have the privilege of your
Yes,
assistance.
my lord.
Huh?
It's my luck also, my lord, to be. Yes. Paragraph 18. Let me read, my lord.
Para 18, 1 second. Let me also reach to paragraph 18.
Yes.
Yes. Please read para 18.
In the present case, first respondent, my lord, lordship is.
Yes.
Yes. First respondent relied upon an entry in the case diary, allegedly made at 6:10 p.m. on 10th June 24, which records that the appellant was arrested after informing him of the ground of arrest. For the reason which will follow hereafter, we are rejecting the argument made by the first respondent. If the police want to probe communication of the grounds of arrest only based on a diary entry, it is necessary to incorporate those grounds of arrest in the diary entry or any other document. The grounds of arrest must exist before the same are
So
informed.
therefore, simply showing that you have been informed is not
No,
sufficient.
it will not serve the purpose.
The grounds of arrest must exist.
Yes,
And
yes.
it must exist in the case diary.
Yes,
Right?
yes, my.
Yes. Now go ahead.
The grounds of arrest must exist before the same are informed. Therefore, in a given case, even assuming that the case of police regarding requirement of Article 21 of the
22(1)
Constitution is to be accepted based on an entry in the case diary, there must be a contemporaneous
record.
which records what the ground of arrest
Arrest
were.
Yes, where
Very
is
clear.
this? You've pointed out. Where is it in your case diary that the grounds of arrest are there? This is merely information. You are saying that you are hereby informed.
Next line.
What is the information? Are you understanding what I'm saying? The notice says in course of investigation of the above reference case, sufficient evidence collected against you for which you have been arrested. Is that sufficient? The offense charge so and so.
May I respectful
Which
submission?
is the interpretation of Article 22
Because
1.
what he has to understand, what is this, not an elaborate. Something more must probably be there. I'm going to give you time to look into this.
Lordship.
Let us be clear.
Yes,
You
my lord.
see,
Yes.
because serious rights of the petitioner are at stake, correct? A fundamental and constitutional right. We must balance
Lordship.
both.
My lord,
The
obviously.
case is also of NDPS, 37 records are also there.
Yes.
So
yes.
we have to balance. So you go through this.
Lordship.
You find out if there is something more in the
Lordship.
records which indicates that the grounds of arrest is there.
Lordship.
Because once the petitioner, you go through Vihan Kumar also properly, because what is the ratio in Vihan Kumar? That is at page 21, para 21. Mr. Nath, please read para
My lord.
21 1.
My lord, yes. Conclusions. Therefore, we conclude the requirement of informing a person arrested of grounds of arrest is a mandatory requirement of Article 22(1). The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge
you
of
see,
the
Mr.
basic
Sharma.
facts. This is important. The sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person. It says arrested person.
You see, because it's not an empty formality.
Yes, yes. Effectively, in the language which is understand. Even, my lord, it means if you write in Hindi and person is of maybe he's a Naga, then you will not serve the purpose.
Then the mode and method.
Yes, the mode and method of communication must be such that the object of the constitutional safeguard is
Is
achieved.
achieved.
That's the purpose. When arrested accused alleges non-compliance with the requirement of 22(1), the burden will always be on the investigation officer agency to prove compliance
So that
with
is
the
why I'm
requirement.
saying, now
records.
he has taken this ground. So it is your burden to show that it has been informed. Simply referring this notice will not do. This notice,
Understand, Lordship.
huh?
I understand.
Yes. So you have to go through it and see whether there is something more. If it is something more, of course. But if there is nothing, then perhaps
Yes.
we'll have to grant the bail.
I'll just go
Yes,
through it.
now,
Yes. Non-compliance with Article 22(1) will be a violation of the fundamental rights of the accused guaranteed under the said article. Moreover, it will amount to a violation of the right to personal liberty guaranteed under Article 21 of the Constitution. Therefore, non-compliance with the requirements of Article 22(1) vitiates the arrest of the accused. Hence, further orders passed by a criminal court of remand are also vitiated. Needless to add that it will not vitiate the investigation, charge sheet, and a trial. But at the same time, filing of charge sheet will not validate a breach of constitutional mandate under Article 22(1). When an arrested person is produced before the judicial magistrate for remand, it is duty of the magistrate to ascertain whether compliance with Article 22(1) and other mandatory requirements safeguards have been made, and when a violation of Article 22(1) is established, it is the duty of the court to forthwith order the release of the accused. That will be a ground for to grant bail,
even if
statutory restrictions on the grant of bail exist. The statutory restrictions do not affect the power of the court to grant bail when violation of Article 22(1) and 22 Constitution is established.
so the record of 37 will not
No,
come.
not serve the power, because ultimately Constitution.
So basically, you see, they have taken this ground. So, Mr. Sharma, you show you have
After some time.
after some time. Okay. You can make a photocopy of Vihan Kumar and
Yes,
return it to Mr. Shekhar
I'll-
after some time, huh? You had given this case law, Kabiluddin.
That is also elaborate. Lordship has quoted everything there.
But you
Finish
see,
that.
because the facts was different, in your case, now this point has to be also dealt with. That whether that
it happens,
that
my
notice
Yeah.
where it says that you are suspected because of this,
Yes, yes,
whether
so
that
much
is
about that.
sufficient.
Of course, in each case, facts are little risk.
Okay, 14.
Your Lordship.
14 is 20C NDPS.
Date of
Yes.
My date of arrest is 4/7/22 and more than 2 years, 9 months behind the bar.
4/7/22.
4/7/22,
2 years,
more than 9 months.
2 years,
2 years, 9 months.
9 months. Commercial quantity.
Yes, Lordship.
Lordship, the
What is
case not
the-
progressing, Lordship.
What is the state of the trial? Do you have the information or otherwise get the updated?
Lordship, the 4 PWs have already been examined
Out of?
out of 6.
Out of 6. So 2 aren't left. When
Yes.
is the next date fixed?
And although, I am sorry, Lordship, 5 have been examined out of 6.
So 1 is left.
1 is left.
When
Lordship.
is the next date?
Next date, Lordship, the record from the record, Lordship, I saw 29/3/25.
That
So
must have, that is over. What happened?
I do not really.
Have they updated?
Yes, yes, let it be updated, Lordship.
Heard MS
Hideka.
so also heard Mr. B. Sharma, Leonard APP for the state respondent. Mr. B. Sharma, Leonard APP submits that from the case scan copy.
Yes.
From the
understand.
scan copy of the case records available, it appears that out of 6 prosecution witnesses, 5 has already been examined, and the remain and the one and the only one which and one prosecution witness was scheduled for examination on
29/3
29/3/2025.
is
that-
the IO, Lordship, only
Huh?
the IO. Only the IO is left to be examined.
who he says is the investigating officer. That being so, let the updated case records be placed before, be called for through the registry of this
Registry.
court and placed before this court on the next date of listing. List on so and so. List on 14, huh? For the that you say that MS your name?
Hideka, Gitanjali
Hideka.
Hideka.
MSG Deka, Learned Counsel for the petitioner submits that the petitioner was arrested on 4/7/2022 and has been languishing in jail since last 2 years, 9 months, and that the trial is commencing, is progressing very slow. However, then you say, huh? And then, all right, date delay. Yes.
I'm sorry, my lord, CD we have not received.
Did you not receive?
Please, your
CD
lordship.
or even FSL report was called for?
That is scan through.
Await up-to-date case diary, as
Please, your
called for
lordship.
along with FSL report by this court earlier on 25/3/2025. Yes, when?
Your lordship, in this matter, charge sheet has been already been filed and kindly matter may be allowed to proceed before concerned court.
Then we have to take instruction whether Sashid Malad.
When?
Day after tomorrow can be listed, my lord.
Cut that thing. MS?
S. Ahmed.
S. Ahmed, Learned Counsel for the petitioner submits that the charge sheet has been filed in the instant matter. Accordingly, Mr. K.K. Parashar, Learned APP for the state respondent seeks a short accommodation to verify as whether to apprise this court as whether the charge sheet has been filed or not. List on such and such date. Wildlife.
May I please, your lord?
My lord, so I informed that my lord, charge sheet has been filed, my lord. But my lord, the number and my lord, date, my lord, not mentioned. But it is coming up, my lord. Maybe fix on my lord, day after tomorrow, my lord, I will provide all information.
As prayed for by Mr. B. Sharma,
My lord.
Learned APP for the state
Learned special PP wildlife.
Learned Special PP Wildlife list this matter tomorrow data on tomorrow day after.
Day after tomorrow.
Tomorrow is Thursday, no? Friday court. On so and so date to apprise the court as whether the charge sheet has been filed or not.
17.
Commercial quantity, Mr. Ahmed?
Yes, Lordship, commercial quantity,
Please.
taking that ground, Lordship, ground of arrests were not furnished. I'm having the certified copies, Lordship, case diary, they have not received.
CD not received, my
Did
lord.
not receive.
The short date.
Because you see,
from
last
Korean-
time there is an order, perusal of case diary would be necessary.
Yes, Lordship.
So,
Korean-
have it. Where are you getting the CD from?
From Korimganj because of that. Today is the
Karimganj.
second date after.
Await CD, issue reminder, list on
Six, Lordship.
Make it 8, my lord.
8. 7.
7. 7, my lord.
7.
I love it.
365.
But here, those scan copy received, but as per office note dated, my lord, 28/4/25, service still awaited, my lord. They have taken station on 23rd of March only.
Await service report in respect of the informant. Informant.
Information, yes.
Informant R2.
R2.
R2. List after 2 weeks on a date to be fixed by the registry. Service is awaited. Let us first see the report. How can we appoint an amicus immediately? This is that case.
Yes, my lord.
Mr. Rahman is not there.
Yes,
Should we
Lordship.
see- Yes, Mr. Rahman. Yes,
Yes.
where is Miss Kumari? Yes,
Lordship, I have already filed that short notes, my lord.
yes.
I've also submitted a short note.
All right, Paisa, short notes for Paisa. Yes,
Yes, Your Lordship. I tried to collect certain judgment. So from the Bombay High Court, there is a judgment.
judgment will come later. Why was this matter fixed today?
With regard to the memo of arrest and the ground of
With regard to the case diary, where
case
is
diary.
it?
Case diary, I have brought it.
Why is
Case
the
diary
case
is there.
diary kept outside? The matter is fixed today for perusal of the case diary. Please first give us the case diary.
It is there. It is
You will argue thereafter. First, let us see what is there in the case diary. Judgments of high courts would are all contextual and persuasive. Other high courts. We will go to it.
I'm trying to get the photo-state copy. That is why it's.
So we can call it after some time. No problem. All right, Mr. Rahman, just wait for some time. Mr.
Yes,
Shekhar,
Lord.
wait for some
We
time.
have
Let
to get
her.
certain photo-state. We have got it from the Manipur. That is.
All right, that's all right. You say so. This court is accommodating you. I
Much
think she
obliged.
has come. No. Are you all ready with the case diary?
Yes.
Photocopies have come. All right, give.
State police photocopy is also there. The arrest memo is there. Of course, they have not given the ground of arrest. Arrest memo is there. Because of the emergent situation, maybe that is one reason. Because
Any other document where, just 1 second, Ekme Rupa. Can you, is the production order there when they were produced before immediately after arrest? Is that order there?
production.
And anywhere in the case diary is the grounds of arrest?
That is
there-
what we are searching the anywhere, somewhere in the.
Is
case
there or
diary.
not there?
No.
If you want some more time to look into, I can call it after some time. You have a look at it. If there is anywhere the grounds of arrest is mentioned, number 1. Number 2, the order whereby they were produced before the magistrate. That order this court also wants to see. It should be available there.
Yes, it
Right?
is there in the state court's order is also.
Can you read it?
Magistrate court order निकालिए. It's the order.
Ma'am, you can read it. Inshallah, please, after some time. Mr. Raman, we'll take it after some time. Let her peruse it properly.
Yes, Lordship.
May I please your lordship? The bail application, my lord.
POXO,
Also, my lordship.
notices have been served.
My lordship, I have taken the same ground, my lords. Same grounds,
Yes,
my
but
lordship.
notices have been served or
My lord,
not?
kindly peruse page number 25, my lordship.
Notices have been served or not?
Not my lord, grounds has been not mentioned. Notice served, my lord.
Huh?
Kindly see page number 20.
The note, office note 24/4/25 says service report.
Day after tomorrow, Lordship.
Mr. KK Das, Leonard APP for no, Taragot Diba. Office note dated 24/4/2025 indicates that the service in respect of the respondent number 2 informant is still awaited. Let Mr. KK Das, Leonard APP for the state respondent apprise seek a report from the jurisdictional police station as regards the status of service. List day after
Day after
on so and so.
Highly obliged, my lord.
May it please your lordship?
Yeah.
Lordship, can you pass over this matter for the time being, lordship?
Time being.
Lord.
Okay.
Obliged.
It is there or not? 19.
Obliged.
POXO. CD is there. Turn off the video, huh? POXO. Huh?
Finally, the matter may be adjourned.
Adjourn. Why?
Conducting counsel is
Unavailable. You're on interim.
no lordship.
Item 20, no? 20, my lord, step received by the registry only on 22nd of April. Service still awaited. Those CD received, my lord.
He wants time. Huh?
Service also awaited, my lord.
Service is awaited.
Notice
No,
has to be
but
served.
you see, these services, you can always find out the report from the police station. So you get a report.
My
Seek
lord.
for a report. These are not normal writ petitions. So
No, no, my
let us
lord.
not keep these matters pending. Okay.
But they have taken steps only on 22nd for
You
police-
seek for a
my lord,
report.
my lord.
The police.
From the IO, my lord,
You
yes,
see,
sir.
they have to also act a little
My lord, my lord,
vigilantly, isn't it?
my lord.
It appears that service in respect of respondent number 2 informant is still awaited as per the office note dated 22/4/2025. Stop. In this connection, Mr. KK Parasar, Leonard APP for the state respondent shall obtain instructions from the jurisdictional police station as regards the status of the service of notice in respect of the respondent number 2. List on such and such date. Okay, agor order to NK diba. List on such and such date. Yes, when?
7, my lord.
Translated copies of evidence of witnesses.
Yes, Lordship. I have already submitted, Lordship,
You submitted.
yesterday only.
So then matter can
But
be.
perhaps the translated copy has not been furnished with the record, case record, Lordship.
Then I'll ask the registry to verify and place it. Mr. UB Sharma, Leonard Counsel for the appellant submits that as per this court,
Order dated 9/5/2024.
as per this court's earlier order dated 9/5/2024, he has submitted the translated copies of the evidence of the witnesses.
Yes, Lordship.
However, yesterday.
Yesterday only.
Yesterday, I so and so did. However, the same is not on record. Let registry verify and place the same on record. List on such and such date.
Highly obliged. Highly obliged, Lordship. Kindly some other than Lordship, 8 May.
All right, no problem. 13th May.
Obliged. Morning, Lordship. Morning.
Yes.
Actually, this is a matter where this the combination of delay was not allowed actually. We have taken the
Delay
steps also.
continuation is not allowed.
We had applied for some 200 and 15 days actually. Out
Hmm.
of this, 95 days was allowed since I was in the hospital, but another 135 days was not allowed, stating that the day to day, the day to day, I have not explained it.
Mr. Counsel, why is this RFA for orders today? You don't know.
I don't know why it has came over here, but I just saw the cause list and that came.
Huh?
I have shown the cause list which says that this is the case is mentioned over here, so that's why I come.
Case
I
is
am also-
mentioned for
No, for orders, I also don't know because I just
Mr.
recently taken-
Counsel. It is very sad that if this court has to tell the councils as what they have to do, when matters are listed under the order column, they are listed for some specific reasons. Now, now for that matter, you have to look into the court's file at 10th before 10:30 and see why it has been placed and accordingly assist the court when the matter is reached. This is
Very-
the this is the
I'm-
ba-
I'm-
this
I'm
is the
very grateful to
basic
you.
courtesy which the court wants from the lawyers. That's
And
all.
my-
Now,
yeah,
now you see, so much time has been wasted. This bench is presently taking up criminal bail matters relating to special statutes.
Yes, that's what.
Unnecessary judicial time is being wasted. If you would have simply pointed out why it has come, I can pass the order immediately. Yes. You have not even
No,
seen
I've-
the office
I have
note.
not.
It says as directed by this court, the notice could not be issued to the sole respondent as the learned advocate has not submitted the written up notice despite request. Further, only Talabana has been submitted, but no postal Talabana has been received in this section yet. You have not even done anything and you have started submitting on merit. You don't even look into the office note as why
I'm
matters
sorry, I
have
have
been
not
listed
seen.
in the orders.
I-
No,
I
this is not expected from lawyers. Why have you not taken steps? I can dismiss it right away. You're going to take the steps or not?
I will be going to take the steps.
Mr.
I.S. Majumdar.
The IS Majumdar Learned Counsel for the appellant assures that the steps as required, the steps as directed by this court earlier by order dated 10/3/2025 shall be taken up, shall be taken within a period of
1 week time.
1 week,
Actually,
3 days
Oh,
from today.
okay.
In view of the aforesaid assurance, list this matter after 2 weeks on a date to be fixed by the registry.
Oblige.
It is needless. Okay. Okay. Yes,
Appearance is completed. They have appeared. I am the appellant.
you are.
I am the appellant, plaintiff appellant. If I have one.
PCR has come.
Yes, CR has not yet probably.
It has not come. No, it says it has been received. You are appearing for the sole
Sole
respondent.
respondent, yes.
So then matter is ready.
Matter is ready for hearing, Lordship. A date may be fixed, convenient date. may
It
be fixed.
appears that the no, heard Mr. H.K. Sharma.
I am HK.
H.K. Sharma, Learned Counsel for the appellant, also heard Mr.
Wasim Haq.
Wasim Haq, Learned Counsel for the respondent, sole respondent, for the sole respondent. It appears that service is completed. It further appears that the TCR, as has been called for by this court by order dated 16/12/2024, has been received in the section, and the same is available on record. List for hearing in the month of
The month of May, in the last part, Lordship.
in the month of July 2025
Soon after the vacation.
on a
Lordship.
date to be fixed by the registry.
Soon after the vacation, Lordship.
Yes, next.
Of vacation.
What is the IA for?
I have for a stay of the execution.
IA to logote DD.
May I please, Your Lordship? Lordship, the steps of the response has been taken on 13/12/2024.
It's still awaited.
Lordship, but it is issued only on 22nd of April, Lordship. The office note dated 25, Lordship.
So it will be await service. Await service, list on after 2 weeks,
Take some time.
list after 3 weeks on a date to be fixed by the registry. Some time was
For the
sought
sole
for it.
respondent in this case.
You
LCR
wanted
has
time.
Yes, my senior, already there is a leave note, your lordships.
Huh?
There is a
All
leave
right,
note.
just 1 second. Yes,
LCR has been received, it may be fixed for hearing only.
LCR has been received.
Appeal has already been admitted.
Right, I'm going to fix it for hearing.
My lordship, I saw the file today. There was some difficulty, lordship. In IA 525, it was for condonation of delay, lordship.
Delay is not condoned.
It
Delay
has
is
already
condoned,
been
lordship,
condoned.
but the order has been passed in IA 2072, lordship. Kindly peruse the record, lordship.
What, Mr. Goswami?
So
Actually, before the appeal was admitted, I was not there because I'm not aware.
What is he saying?
525 as it appears, I have checked the records, it is for condonation of delay. The delay was condoned by the Honorable Supreme Court. So appeal was thereafter admitted on 18th of March 2025. Your Lordship.
Okay.
2072 was for stay, lordship.
So what
But-
is to be done?
That is not come up today, lordship.
So it's all right. I'm fixing your matter for hearing. Are you having any problem in that?
No, lordship.
You don't want the appeal to be heard?
Yes, lordship.
Huh?
Yes, lordship.
Then- What kind of submissions are you making? You should be happy your matter is getting fixed for hearing. You want to delay it. Then? Heard, Mr.
Okay, boss.
E.
Okay, boss.
P.K. Basu, learned counsel for the appellant, also heard Mr. D. Goswami, learned counsel for the sole respondent. It appears that the TCR as called for has been received. The matter appears to be ready for hearing. Let the matter be listed for hearing.
As per your Lordship convenience, but it has to be some early date, my lord, because it's
In the month
pending
of,
non-payment of contractual bills.
In
my
the
lord.
month of June 2025, on a
Deeply
date to be fixed by the registry.
Deeply obliged.
Case diary. Can you let me know?
His Lordship.
Yes,
Item number 30 and 31 are out of same FIR. Out of same FIR.
30 and 31 is same
Same
FIR.
FIR.
30 and 31. Yes,
Lordship may kindly take up 804, that is 31.
31 or
Because-
531.
That's memo. Respect of the accused number 1 is annexed with this. Page,
Just 1 sec. Miss Kumari, what about the other case? Have you gone through or not? Are you ready with the other
Yes,
one?
yes.
Before I take this up,
Oh,
because
that one Manipur case.
Huh.
Yes, I am preparing for that, na? Flag marking.
Yes, Mr. Purkasta,
may I please Lordship take to page 65. This is a search memo,
page
65.
5.
Same, this is in respect of accused number 1,
1 second. 65, right?
annexed at 10. And skip page.
Actually, generally, the marking should be,
This is reverse side.
it's easier. Yes, 65.
This is in respect of Pinku Kumar, is the accused number 1. Now, Lordship may kindly come to page 66.
1 second. Is who?
Is accused number 1,
Where do I
Is the
get the
public servant.
name?
Pinku Kumar. In the column number 3, top page 65, his name is
I
there.
don't get his name.
Column number 3, Lordship. Oh, sorry, column number 4. 1, 2, 3, 4. Second paragraph, second right side, residential
Yes.
premises of Sri Pinku Kumar.
Oh, Pinku Kumar. He is the petitioner.
No, he is the petitioner in this case. Yes, 31. He is the accused number 1.
Yes,
While searching his case, CBI has seized certain documents
yes.
at page 65. So I am referring these
because I am relying upon those documents in this FIR, Lordship.
Yes.
The serial number L, Lordship, page 66
Yes.
in the left column.
Yes.
Is agreement between Priyanka Kumari and Suman Pal. L.
Which one? Page 66.
66, L. Left side, all L, left column.
L. A bunch of documents.
Documents, yes.
Read that.
There are A, B, C, D below
Oh,
L.
Okay, okay, ABCD, yes.
L. Agreement between Priyanka
One
Kumari
sec,
and
one
Suman
sec.
Pal.
L.
Left side, Lordship, left.
Yes, got it.
Then M. Letter from
And M.
Suman Pal to Priyanka Kumari.
Yes.
Then N. Legal notice to Priyanka Kumari from Suman Pal.
Yes.
Then O. Agreement between Suman Pal and Priyanka Kumari along with its terms.
Yes.
This is the document which I am relying upon to show that the custodial interrogation in this case is not required.
Yes.
And another two more documents just I would refer because this will be the next case, Lordship. This is K1, K. Notarial certificate and deed of agreement sold between K. Yadav Pal and Pinku Kumar. This is will be the next this next FIR.
A is for the second case.
Second
That
FIR.
accused 2.
Not Lordship, second FIR. So that I do not need not to come again in this second FIR. This is 30 to 33.
But I don't think both the FIR we can file dispose it off together. For that, I think perhaps we'll have to deal with separately.
Just to mention that these
Okay,
words
okay.
I will rely upon this K and P.
K and P.
K, P and Q.
2. These are for second case.
Second FIR.
Yes.
Now, it is clear from that there is an agreement for sale of land between the accused number 2 and wife of the accused number 1.
So the agreement
For
is for sale of land
sale.
between
Wife of the accused number 1, Priyanka
wife
Kumari,
of accused number 1
and
and
accused number 2.
number 2.
And in this respect, payments were made on installments,
Yes.
total 40,95,000 on installments. Out of this, 28 lakh something was into the account of wife and 12 lakh something into the account of this accused number 1. Now, subsequently it failed, Lordship. It failed. Lordship may kindly come to page 40. The accused number 2 rescinded.
Page
40.
40.
40.
Yes.
Now, accused number 2 writes to this wife of accused number 1. I would like to inform that I have made an agreement with you for purchase of your piece of land at Patna by agreement dated 23/5/2023 for rupees 58 lakh, out of which I have already paid you on an amount to rupees 41 lakh. Since I have bought a ready-made house in my hometown, now I am not able to arrange the remaining money for purchase of your piece of land, and also I have to pay some amount to owner of the house which I have purchased at hometown. So it is difficult for me to arrange the remaining money. So he rescinded and requested a refund of the money. It was dated Lordship 2/6/2024.
This is Suman Paul is that husband, accused 1.
No, Suman Pal is the accused number 2. He is in item number 31 petitioner.
And
30.
the agreement was between him and the
wife
of accused 1, isn't it?
That's how transaction was made.
Yes.
For that. Thereafter, he issued a legal notice because
Kumar, you can take your seat. Yes.
because his payment was not refunded as demanded, he issued a legal notice that is on 10/9/2024. 10/9/2024, page 41. Again, demanding refund of the money.
Page
41.
এই ৰেজিষ্ট্ৰি ক'ব যে এনেকুৱা ডকুমেন্টছ থাকিলে পেজ নম্বৰ লাগে না ফাইলিঙত চেক কৰিব ক'ব না মাতি পঠাব নহ'লে ফাইলিঙৰ কাবাক পেজ
41.
41. Yes.
That legal notice, he demanded again through advocate. His signature is also there, Suman Pal, that
demanding refund of rupees 41 lakhs. May I please read, Lordship?
Yes, please.
Priyanka Kumari, Madam, as instructed for my aforementioned client, I am hereby serving this legal notice upon you, following facts and cause therefore. That you, the notice receiver, and my notice giver client stepped into an agreement on 23/5/2023. That as per the agreement, you, the notice receiver, had to sell your land to my client at fixed amount of rupees 58 lakhs as agreed upon. That from the fixed amount, my notice giver client paid a sum of rupees 41 lakhs on various dates. That after paying the amount, my notice giver client, due to financial paucity, could not pay the whole amount in due time, and hence the agreement period get over. That my client has already
He wants the money back.
money back. Yes. Now,
Mr. Purkasta, I'm sorry. You see, I have in between, I have dealt with so many applications. I have actually forgotten
FIR.
the FIR.
FIR.
So just tell me in brief, what was the allegation in the FIR?
Allegation that accused number 1 through accused number 2 collected money from bribe money for granting express credit loan, and that bribe money amounts to this amount, 41 lakhs.
And this amount which is there in the in the account, that is for how they are suspecting.
Yeah, yes, that is how they are suspecting.
But otherwise, the allegation is that the accused number 1.
Accused number 1 is the bank manager.
He had
He has granted these loans, express credit loan. These are personal loans below 10 lakhs given to government employees, salaried persons only.
and collected money.
Yes, and collected money.
So that is how because they say that loan is granted to accused 2, and it is shown that accused 2 had paid money to the wife.
No, loan is not granted to accused. Loan, there are allegations the loan is granted to several persons.
Those are not before the court.
Those are not before, and their names are not there. This is
file the FIR.
Source information. That is interesting. There is no preliminary inquiry. That is why we have made a statement also. Had there been a preliminary inquiry before registration, perhaps it could have been avoided.
All right.
And that amount has been refunded by this Priyanka Kumari Lordship.
These are AB.
AB.
FIR is registered.
Registered. FIR is registered.
Yes.
Okay. Refunded by this Priyanka Kumari. All the total 41 lakhs. Next page is the statement of accounts of Priyanka Kumari Lordship.
Page
43. First entry, Lordship, 8 October 2024, that is 1 lakh. Then page 44, Lordship, page 16th October, third entry credit, 5 lakhs. Then same date, again 5 lakhs. It becomes 11 lakhs. Then 18th October, 10 lakhs. 19th October, 10 lakhs. 20 October, 10 lakhs. Total 41 lakh. Thereafter refunded after the service of legal notice has been refunded. And this can be corroborated, Lordship, from the item number 30. This the petitioner and Shumenpal is petitioner from his statement of account also.
Let's go to the FIR once.
Lordship. Page.
Have you completed or you wanted to show something more?
Only statement of account. This is what I have stated. This corroboration of this.
Because I don't want to interrupt your flow. So if you have completed, let's come back to the FIR.
FIR, Lordship, page 22, Lordship may come. Page 22. It starts from 20. 22 is their information, contents of information.
Yes.
It says a reliable source information.
Yes, please.
A reliable source information has been received to the effect that Sri Pinku Kumar, manager scale 3, while working as branch manager of State Bank of India, Ramkrishnanagar branch, Karimganj, Assam, in conspiracy with middleman Shumenpal, disbursed express credit loans to various borrowers during the period 2023 to 2024.
Shumenpal is the petitioner in the second case, na?
Shumenpal is the item number. No, in this case.
Correct. In the second, in the first FIR, accused 2.
Accused number 2. And petitioner in item number 30.
Yes.
Source information further alleged that undue advantage of bribe of total rupees 40.95 lakhs approx were collected by middleman Shumenpal in conspiracy with Sri Pinku Kumar and unknown others And thereafter, Sri Suman Pal credited an amount of rupees 12.10 lakhs approx in the bank account number such and such of Sri Pinku Kumar with Canara Bank, and remaining amount of rupees 28.85 lakhs approx in the bank account number such and such of Priyanka Kumari from his bank account. Source information also alleged that after obtaining undue advantage, bribes from Sri Suman Pal and unknown others, Sri Pinku Kumar tried to divert the said bribe amount in the bank accounts of his relatives and others. This is the allegation, Lordship. No, the entire amount has been refunded. It is
You are not on interim.
I'm not on interim, Lordship. So this is the case, and allegations that, Lordship, during the period 23 to 2024, I beg to Lordship
20?
23 to 24. Back to lost. This is while he was posted as branch manager, State Bank of India, Ramkrishna Nagar branch. Now, I beg to take a Lordship to page 55. This is the employment biodata of Pinku Kumar. And then page 25. Then page 26. He was there from 3/7/2023 to 19.
Page
26.
He was there from
3/7/2023.
3/7
to 19/3/2024.
to 19.
19/3/2024.
Kumari, just what I was thinking is, why don't I don't dispose the anticipatory bail right now, but why don't we give an interim bail directing them to appear before the investigating officer?
The issue.
Huh?
Because we have again asked them to appear and unlock the premises. They have avoided.
So that is why
Consequent
I'm
upon
saying-
which we have to break open the
You see,
flat.
that is why I'm saying that why not we give them an interim bail, let him appear before the IO on within 10 days. And if he does not, then on the 11th day, that protection gets
I would
cancelled.
like to draw your kind attention.
Because you
with
see,
with their own document.
But that's all right. See, I am not convicting the accused at this stage, right? We are only considering whether to grant bail, anticipatory bail or not. Since there are documents indicating that some transactions were going on. So if he appears before the investigating officer, perhaps more things will come and things would get clear.
But
See, I am not disposing
he
it
is
off.
holding such a
I
post
understand that the allegations are
and it is
serious.
in the initial stage.
Correct. That is why I am not disposing of this anticipatory bail application today. I am only granting him an interim bail to ensure that he appears and his statements are recorded.
But
And
before
then
that-
on the next date, you give us the up-to-date case diary and we'll see.
But before that, I would like to draw your kind attention on.
All right, I'm
their
coming
own-
back in 5 minutes, but you please think over what this court has said, because I think that would help your investigation. Because you, at the end of the day, you see the purpose of granting bail is to secure the appearances, right? Now, I don't think there is any criminal antecedent that is available against the petitioner. Is that so? I don't think. Is there anything on, because you see, I can dispose it off right now and grant the anticipatory bail on these grounds. Because just gravity is not the sole criteria. This court has to see whether there are any criminal antecedents, whether there is any material which would prima facie show that he's going to flee from justice, not appear. You see, these are the things, but those are not there in your case diary.
But he being holding such a high post.
true.
He's supposed to cooperate, but even after
for
asking
that
him to
now,
appear,
for that,
he is
would this-
avoiding.
For that, would this court curtail the liberty, which is his fundamental constitutional right?
But
You
it
see-
is in the
you see,
initial
the
stage.
court has to also see that. That is why this court wants to give him that protection. So you think whether you want an interim or otherwise, I'm going to allow it. Just one sec. Matok, I
Before
said
that, I would like to draw the
Matok.
attention to some document
One
they are relying.
তাৰমানে বস্তুটো পেজ নাম্বাৰটো ভিতৰৰ ফালে থাকে ওপৰত থাকিলে আপোনাৰ চাবলৈ
জেনাৰেলি
সুবিধা
আমি আগতে কি কৰিছো come up
Take
with
care
some
of this.
instructions and আপোনালোকে
আমি ধৰি
advocate লক concerned লক notice লৈ আহিব কৰি দিব। হ'ব?
ঠিক আছে।
All right, I'll come back in 5 minutes.
यही रखते हैं।
Number
35.
5. Yes,
This is as per them is the
I
agreement.
cannot read.
Hindi. I'm translating it.
You don't have a translated copy.
It is their
Appendix.
copy.
Where?
Translation is there, Lordship.
Page
Page 30
31.
Page 31.
Let's read the translated.
Yes, sorry. Yes, 31. What I would like to apprise your lordship, it is a bayana. Bayana. It is not an agreement. It is not an agreement as it is stated in the deed of
It is what?
agreement for sale.
What is it?
This is a bayana patra. Bayana patra means a token amount has to be given to the party from which the contract has been entered into. This is not exactly agreement.
Okay, it is some document to
Some
show
document.
that there has
But-
been some
but-
transaction,
Yes, but then I am coming, your
even
lordship.
if it is not agreement.
I respectfully differ.
Yes.
Mr.
No, it is,
Prakasta,
in
sit
the
down.
meaning also it is there. In the Hindi meaning, bayana is not an agreement.
Okay,
And now it is entered on 23/5/2023.
20
3/5/2023.
is entered. When
So
do I get?
total basis is this document which they are
23
related.
5 2023. Yes.
23. Backside of the page is not there when it was issued. All said and done, it is okay, fine. Now at page number 36.
What is this number in this document? It says 23 5. This is stamp
The stamp
401.
date number 401.
And the
But
date
while
is
issuing
23
the NJ
5.
paper, while issuing the NJ paper, they, in the backside, name is there and the date of issue is there. That is very important because it is valid for 6 months only. That is
Counsel,
the question of trial.
discount, correct.
That
was
is the
about
question
to-
of trial.
You see,
But again, I am coming here,
see,
lordship,
Miss Counsel, I'm again saying.
because they
repeating
are relying
myself,
on this.
I'm repeating myself. I am not convicting the accused right now. I'm not the convicting court. I'm not in, so therefore, please show me if there are any grounds, any materials for not granting bail.
That is why
available.
this is a
This
manufacturer
this
based
is
on
not a
manufactured
document.
document.
This is not a document for that exercise. I have already said that yes, the offense that is alleged is grave. This is one parameter. You need not go into that area. That is not the sole criteria. Is there anything in the case diary to indicate as regards the criminal antecedent of the petitioner? Is there anything in the case diary to indicate that the petitioner shall flee from justice? Is that there?
But before that, I
No,
would
no,
like
is
to
that
apprise
there?
what
Because
is the.
you see, this
No.
court is not going to go into the
But on 23/5, how they can say they have received the amount on
That
6/10/23 in
that is
advance?
why I am
And this
saying
agreement is there.
that I am granting them the anticipatory bail.
They
They
can-
will appear.
They will prepare this type of document again.
What is your investigating people doing? They have to investigate. They may prepare, but it is for you to investigate. Now, just because assuming they will do
But
something,
But on 23/5/2023, they are saying that they have received an amount of rupees 15,000 of 13/11/23. Here it is written 15,000 rupya pai. That means she has received beforehand. Page 36, and translation is also wrong.
read
Page
that.
36, Hindi.
Hindi version.
Hindi,
read.
they have entered on 23/5/23 and here Dinank 13/11 in all 3/10/23 3/10/23 much after, and here it is 13,000 rupya pai, means she has received. How it is possible to prepare this type of document?
I am
And
allowing
this paper,
Miss
this paper
Counsel,
is
I am not
added.
right now disposing of this anticipatory bail application, but I am giving him an interim protection. Let him appear. 7 days. Within 7 days, you appear. Otherwise, on the interim protection gets cancelled. Take their statement and find out and come back. And if there is anything more, certainly this court will not
But
make that absolute.
This is very strange. This document.
Let us
has
see what
so-
happens. Let us see what happens. Heard Mr. S.D. Purkasta, learned counsel for the petitioner. It item number 45 to first. Huh? Take 45 first.
It's not, today is not 45, today
Today is
31.
not 45.
80, AB 804.
Huh?
804. Lordship.
804.
804
Marking to
is 31.
AB 804. Huh? And also heard MS M. Kumari. M. Kumari or Kumar?
Kumari, Manorama Kumari.
M. Kumari, learned standing counsel CBI. Huh? You are practicing counsel from
This
here?
one only.
Huh?
I was practicing here only. Earlier, I was senior counsel of for the special judge CBI,
Acha, acha.
prosecutor. Then I was elevated as a NCLT judge, posted first in the Kolkata,
Okay.
then Ahmedabad.
All right.
Completing the tenure, I came back.
All right. M. Kumari, learned standing counsel CBI, huh? For the respondent. This is an application under section 482 of the BNSS 2023. Application and for granting of anticipatory bail to the petitioner I. Sri Pinku Kumar. The brief facts of the case is as follows, paragraph 3. Mr. So-and-so Purkasta learned counsel for the petitioner submits that that it is evident from the documents seized by the investigating officer that there was an agreement. What do you call that in Hindi?
Bana Patra.
Can you please put it in the
Paper, yes, Bana Patra.
in English so that I can put it? Huh?
BIANA, Bayana.
I put it within bracket to show that there was a transaction, that there was an agreement between, that there was some agreement between the wife of the petitioner and one so and so,
Accused number 2.
and the accused number 2 for sale of land,
Purchase and sale of land.
for purchase and sale of land, and it was in regard of the said transaction that certain money was paid in the account of the wife of petitioner,
As
well as the petitioner. He further submits that further documents seized also indicates that because the sale did not work out, the transaction was failed. Sorry, because the sale didn't work out, the money was returned back as demanded. Stop. MS so and so learned counsel, by referring to the agreement within brackets so and so, refers that the money, the amount mentioned here is 15,000. 15,000, Ms. Kumari, 15,000, the amount mentioned in the agreement in the Hindi version.
No, Hindi version, on number of occasion, phase wise, it is written.
She submits that no original date no date is mentioned at the back of the agreement.
Bayana Patra,
brackets, so
Bayana
and so.
Patra.
Yes. She further questions the authenticity of these documents. However, it appears that in order to unearth the truth, the appearance of the petitioner is essential. The appearance of the petitioner before the investigating officer is essential. It further appears from the case diary placed before this court that there is nothing adverse as regards the criminal antecedent of the petitioner, nor any materials, nor it is the case of the learned counsel, learned standing counsel, CBI, that there is apprehension that the petitioner shall flee away from justice, discernible from the materials before this court. Materials placed before this court. Materials available in the case diary. Be that as it may, undoubtedly the offense is grave. However, in order to consider the prayer of pre-arrest bail, it would be essential this court deems appropriate at this stage to grant interim protection to the petitioner, deems appropriate to direct the petitioner to appear before the investigating officer so as to ensure, so that the investigating officer can complete the investigation. Accordingly, considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioner named above, shall be released on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 50,000. 50,000? 50,000
As your
with
lordship, please.
one surety, two surety.
As your lordship, please.
With two surety of the amount to the satisfaction of the arresting authority, subject of course to the following conditions. Number one, that the petitioner shall appear before the investigating officer within 7 days, failing which on and from the 8th day, the interim pre-arrest bail order shall have no force. Number two, or three, Didiba, plus Didiba that he shall hand over his passport. You are from here?
From Patna, actually.
Shall hand
Now
o-
he is posted at Silchar. He from
shall
Patna.
hand over duta additional conditions logai diba eta to he passport are not to leave the jurisdiction of the state without informing the trial court. Right? I'm putting two more stricter conditions. When do you want to and let the updated case diary be made available on the next date of listing? List on?
Is that 7 or 8 like?
No, he is going to appear within 7 days.
10th.
So will you be able to get it back? Because you see, the purpose is to see after whether he
Yes.
appears, number one, and what comes after that. That is the whole purpose.
Then
So
15 days at least required after their.
that's right. So
total
you
period.
suggest a
So let
date
it be on.
on such and such date, huh? Now, the other
Seven.
case where the wife,
17.
the
no,
wife is
16.
886.
No, Lordship, wife, no, this is Suman Pal,
Suman Paul is 886.
886.
Now,
19th of
AB
May.
886 নামটো সুমন পল হৈ যাব আৰু যত এলিগেশ্যন আছে that wife wife of accused number 1 and जो तुम्ही accused number 2 কৈছা that petitioner. That's right. That is the only
Yes, yes.
difference.
19th of May.
19th. You followed? Mr. Prakash, please be in court or ask your junior to be in court for a while so that once the order is typed, you can verify because what happened is that when there are 2-3 petitions, sometimes it gets very difficult. 1 or 2 words might get.
I will come, Lordship.
So it is in your interest that you
Lordship.
read the draft.
Deeply obliged.
So these 2 have gone. Which is the other 2?
Other 2.
Pinku
Here,
Kumar and
Pinky
Jadhav.
Kumar is accused number 1.
No, but what is this FIR? This
FIR is
FIR
same, Lordship.
Same. There is a
Same.
transaction in the account. Same
Then
transaction,
the same order.
but there is
Here
no.
it is the Pinku Kumar is
Yes,
the
here they have entered into
Accused
the
number 1.
agreement.
Petitioner.
wife of the petitioner.
No, wife is, yes, no, here not wife, Lordship.
Here
Wife
not-
is not insane.
One middleman, he is the heir. I
Here,
suppose. he
Pinky
is-
Kumar is the accused number.
Let me see the FIR.
Okay. It is 845. Eight four five, Lordship, it is.
Page?
Page 23.
Yes.
It is AB 843. Here only different amount.
Here the middleman is one Jadhav.
Jadhav Pal. This is the accused number 2 in petitioner in the other
So
petition.
here some documents are there or not there?
Here, Lordship.
What
Again,
document?
the
Here,
agreement.
here what?
Same document.
No, not same document.
Why is
Different,
everybody
No,
having documents with your wife?
No. Here it is not like this, Lordship.
Then
Here what happened, while it is page 32, Lordship. This document is there together. The accused number and accused number 2.
yeah, just one sec. In the first case, that money which is mentioned has otherwise been returned back to that person from that account,
It is
right?
Apart from that, there are many transactions in the UPI that has to be
Ascertained.
ascertained.
You look into it. So if there is something,
And in
this
the
court
season
will
number,
not make it absolute.
jewelries are found.
So that is what the only thing is to see whether, so you have you do the interrogation and see what comes
Yes, Your
out.
Honor.
Interim bail doesn't mean that automatically on the next date it will be made absolute. That is not the criteria. The whole purpose is because till date you're not being able to get hold of him. He is not appearing, right?
Exactly.
So I'm only trying to secure that so that the investigation can proceed. All right. Yes,
Come page 64, Lordship.
page
64.
64.
In this case, they together, accused number 1 and 2 together, purchase the land, partnership, wherein accused number 2 has 65% and this accused number 1 has 35%. This is the second deed of agreement sale.
64 is the original document. No, it's a translated.
No date, nothing.
No, it is,
Date is also not there.
no date is there. Certificate is, each stamp is dated 11/2/2025.
No, where is the original document? This looks like a photocopy to me, 60 page from 65.
No, Lordship. Originally seized by them, Lordship.
Huh?
Originally seized by CBI. That K and P I have shown in the search memo.
Is it available in the
CD.
case diary?
CD.
CD is there.
CD is there. I have already submitted the CD once.
CD2. Please see whether this agreement is there because the page 65 doesn't have any date.
Page 65.
Doesn't have any date.
In the each time date is mentioned, but in this main agreement, the date is not mentioned. Yes, Lordship. I may point out, Lordship, connection with the first case. Connection to second case, there was no such. Case diary of first case.
Warrant is there.
These documents are not there.
This document is.
But
not
I
there.
think these documents was part of that first case diary. Because in that FIR, if you, Mr.
First-
Counsel had pointed out that
It may
document
be the
KLOP.
Yes. KOP. APQ.
Transactions were there, but agreement I will have to,
Transactions were there
yes, transactions.
between,
Between Jadhav and Pink Kumar.
and they are saying this transaction
Suman Pal is also there.
the transaction, according to them, is in regards to
Purchasing. land.
purchasing land.
Apart from
Together.
that, there are number of UPI,
With the same persons.
same person.
What are those transactions?
I have annexed the statements. There are, I did not find other else, Lordship. Statement of accounts of both the persons. that
Transaction
I
are
can
made
access.
to relative also, and money relative of the Pinku.
Yes, in this case, what happened? Jadhav Pal is contribution as per their 65% and 30%, because what happened, Lordship, this is in Karimganj district. There's medical college was
Right,
under
let
construction.
us have these two matters posted on that same day. Let us see what happens. Let's see what happens. Let him appear in
19,
regard to
on the
first.
same date, 19.
In the meantime, you return the CD, get it updated. Both, because let's see if something more,
Probably agreement has been made and kept in the Malkhana.
okay, in item 32 and 33, list along with AB 3031 code on the same day.
ये इसमें चला गया था कल जो।
Ms. Counsel, please get the CDs updated, na? Dutata received, ma'am. Even in these two cases, you can return the CD and if something more is there, then they will update it.
They are taking back the CD.
Yes, I have returned it.
Much obliging.
Item number?
Factual, just little fact, let me
Yeah,
please, my. Page number 14 is the FIR, my lord.
Page number?
14, 1-4.
अच्छा ठीक है सर वाला प्रो page 14
14, my lord, yes. Just tracking the vehicle and then arresting those persons with my lord.
yes please
Skip the first two para, third para. 2:30 PM, said passenger from there, my lord. Fact. Hearing number such and such was detained on the road nearby. The passengers inside the bus were informed of our intention of retaining the vehicle. The target person was found sitting inside the vehicle. He was asked to board down the bus along with luggage. Moreover, one more person who is stated to be a companion, such and such, and then come, my lord, in the next paragraph.
read why let's read again.
Okay, my lord. Inside the bus, he was asked to board down the bus along with the luggage. Moreover, one more person who he stated to be his companion was also found sitting next to him in the vehicle. As the other passengers of the bus boarded down the bus, the target person and his accomplice were asked to board down the bus. But as they deferred from obeying the orders, they had to be brought down by us from the vehicle along with the luggage. Having boarded down the bus, we identified ourselves to these two suspects and also informed them of our suspicion on them of having traveling in the bus with suspect NDPS goods. The vehicle's driver, Nijamuddin, such and such, and the handyman, Hujai, such and such, have willingly stood as witness for the search and seizure procedures for possible recovery of NDPS goods from the bags found in the possession of the apprehended suspects, both of them. We have also caused ourselves to be searched in person by the witnesses prior to carrying out search. Thereafter, during the search of the recovered 4 number of bags, 8 numbers of plastic packets wrapped with plastic sellotapes containing green color leaves suspected to be ganjas were found inside the bags. That means they have got 4 bags. In these 4 bags, there are 8 packets. And on weighing the recovered number of plastic packets containing suspected ganja on a digital weight machine, a sum total weight amounted to 30.635 kg. The breakdown is given here, my lord. That's the case they've got. Here, Lordship will see, my lord. 4 bags they have got from 2 persons. And inside these 4 bags, 8 packets. Now the 4 bags for the 2 persons, it is not clear. One is carrying 1 bag or 2 packets, it is not clear. Actually, I'm just saying, it is not clear from here whether he is below 2 grams, 2 kg, or one is holding more than 20 kg is not clear. They have not found it here. So ultimately, he was arrested, both of them were arrested. Next day, my point, why I'm going to show this one. Next day, please come to page number 18, my lord. This question may come subsequently, that's what I'm saying. Arrest, ground of arrest is there. Page number 18. There's an application before the Chief Judicial Magistrate on 20/12/24. My lord, first paragraph, what he writes, with reference to the subject cited above, I have the honor to report that I am forwarding here with below noted arrested accused persons to your honorable court who have been arrested in connection with the above mentioned case reference with a prayer for 2 days police remand for interest of the investigation. Fact, and then bottom, my lord, ground of arrest. Here, my lord, I want to make my submissions.
Where is the judicial magistrate's order? I have seen from there.
Yes.
What does that say?
Regarding
Upon being produced? When was he produced?
Yes.
When was the arrest?
1912.
1912.
12. Yes, 24.
24. And he
Yes.
was produced on 20.
20, yes, 12/24.
12/24.
Yes, yes. That's why I'm just trying to show this.
What is the order?
here, order is here, Lordship.
Read.
The long one, Lordship. Yes, record put up before me, so and so. Seen the forwarding report, so and so. The investigating officer is directed to produce the accused person before the court from police remand on 21/12/24. The next date was fixed for production, Lordship.
21.
21.
On 21, what is the order?
That is not in the case day, Lordship.
Right? And this ground of arrest is there in the case diary.
I'm coming to that if he finishes.
So I'll come back to Mr. Nath later. Is it there?
Lordship, the first thing Lordship will have to see whether he is disputing that 47 notice was not at all given to him, or he is stating that the grounds of arrest is not communicated to him, Lordship.
I
Because
think
these
he
two are
says
different
ground of
things.
arrest is not communicated.
So 47 he is
Not
accept.
No,
disputing.
I'm not disputing, or I don't even know about that. I'm not pressing on that also.
That he's not on that.
47 notice has been
His
given.
only argument is that you have not informed him the grounds of arrest.
Lordship.
Therefore, there is a non-compliance of the
22(1).
constitutional obligation, constitutional and fundamental right enshrined under Article 22(1) of the Constitution of India. This is his argument, correct?
Lordship. Lordship, in the judgment that Lordship has seen given.
Gyan
you-
Kumar.
Yes, Lordship. Here, in that case, Lordship, the main argument was that 47 notice was not at all given, Lordship.
Yes. Yes.
47 notice, that is, Lordship, the grounds of arrest were not at all communicated, Lordship.
Yes.
There was absence of 47 notice. Thereafter, Lordship, the respondent, that is the police investigation side, Lordship, they tried to establish the fact that he was informed about the grounds of arrest based on a police entry, based on a case diary entry, Lordship. Yes, that is the commission. If Lordship kindly comes to paragraph 27 for a moment, Lordship, of that judgment, Lordship.
Yes.
Apart from paragraph 18 that Lordship had asked me to, 27, Lordship.
Yes.
May I read, Lordship?
Yes, please.
Reliance was placed in this regard on the case diary entry of 10th June 24 at 6:10 p.m., which records that the appellant was arrested after informing him of the grounds of arrest. So that was the specific case of the respondents there in Lordship. This was not pleaded before the High Court as well as in this court in the reply of the first respondent. This is an afterthought. Considering the stand taken in the reply filed by the High Court and this court only on the basis of a vague entry in the police diary, we cannot accept that compliance with Article 22(1) can be inferred.
Read.
No
contemporaneous
documents have been put on record wherein the grounds of arrest have been noted. Therefore, reliance placed on the diary entries is completely irrelevant.
You see, now in order, I'm trying to see whether this would help you or not in a given situation. Otherwise, you see, for the last few days, in all cases, court is
On this point.
on this point granting because nothing is there. But when you see, when it says no contemporaneous documents, what does contemporaneous documents would mean? That on the same time. Basically, what I understood from Bihan Kumar after reading and reading is that two things is required. Number one, the grounds of arrest must exist. Right? Number two, it has to be intimated or
Communicated.
informed
Correct.
to the arrest.
Absolutely.
These two things
Absolutely.
has to be there. And the information has to be during around the same time.
Absolutely.
It may not be on the same day, maybe on the next day also.
Okay.
But around the same time, it cannot be after a week. So your case diary or you must satisfy this court from somewhere showing that yes, it has been informed. Now, simply saying that yes, I have informed will not do. Right?
Correct.
Now, and this the notice which is available here says that you have been suspected. Isn't it? What is it? Just read.
Yes. Reference is given to the case, Lordship. These sections are given. Then, Lordship, in course of investigation, the above reference case, sufficient evidence collected against you for which you have been arrested on 20/12/24 at 11 a.m.
It simply says that sufficient evidence has been collected against case so and so.
Yes.
Is the nature of the offense?
Yes.
What has been? Nothing is mentioned.
Next line, Lordship, the offense charged against you falls under purview of non-bailable offense under section so and so, so and so.
Right. Right. Because the other requirement is that you must inform him that he has a right to bail. Correct. That is the other requirement. But as regards grounds of arrest, merely saying that you have been suspected. There are materials, and on the materials, it is suspected that you have committed an offense under section so and so of the NDPS. Can that be said to be sufficient information for the accused to know? Will it be not the grounds of arrest similar to what is there? Because you see, if this were given to him in page 18, something like that, that so much of things was recovered from your possession. Therefore, it is suspected. Would that not be the correct words? Now, it is very difficult for us to say all this because then that becomes a precedent. But I'm giving you an example because if we have to understand Bihan Kumar, then para 20, para 21.
21, yes.
The information of the ground of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted
and
communicated to the arrested person effectively in the language which he understands. So simply saying that, that we have sufficient materials to suspect that you have committed an offense under section 22C.
47 of the if Lordship kindly take.
Equal to 50 of.
All right. Mr. Nath, sit down.
It was 47. 47 to 47, Lordship. Because it was given under BNSS 47, Lordship. This 47 person arrested to be informed of grounds of arrest and of right to bail.
47.
7.
That's all right. You see, now, Mr. Sharma,
Lordship.
the constitutional obligation, the rights which is guaranteed to an arrestee cannot be diluted by some other procedural requirement contained in some other criminal law, correct?
Yes.
It cannot be.
It cannot be. Lordship.
And this right cannot be also tinkered. The constitutional right. Constitution is giving, is guaranteeing it to the arrestee. It cannot be tinkered in any manner. Anyway, you want me to receive 47?
47, just for a moment.
Every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested or other grounds of such arrest.
That has
So
been-
this is more clear. Full particulars of the offense for which he is arrested. Where are the particulars of the offense?
Lordship,
Or other grounds of such arrest? Where are all these particulars?
only Lordship, the non-bailable offense and section have been mentioned. Yes, correct. Lordship.
You see, 47, that's why when we are giving those judgments, we are referring both together.
Yes, yes.
Because 47 is very clear. But here it is not about not compliance of 47 for
But
which the bail is
Particulars and grounds.
being
Yes, yes.
granted in heinous crimes. It is because of the non-compliance of the constitutional
Yes, Lordship.
obligation.
Yes, Lordship.
Article 22(1), how can that be tinkered by the investigating officer?
Correct, Lordship.
Isn't it?
In this
That is
case,
the only thing.
yes, in this case, Lordship, what had happened, Lordship, there was some credible information regarding the transportation.
Maybe.
Yes. And Lordship, he was under surveillance. They, if we notice.
Maybe.
Yes,
But where are those particulars?
yes, on that.
Where are those
And he was
particulars?
caught red-handed, Lordship. Thereafter, Lordship,
Where are those particulars?
not there, Lordship. Whatever is there is before your Lordship in 47 notice and
Where are those particulars? The particulars are not there.
it is Lordship.
Anything more?
Lordship, in this bail application, Lordship, they have not urged that ground, but orally.
No, this ground is not taken in the
But
pleading.
this is not taken, but this is a
No, no.
question of law, my lord.
Mr. Lat, you see, it can be looked in two ways. So it is up to him what he has to say.
My lord.
The moment you urge this ground in Vihan Kumar only you have seen, you've read it out. The onus is on them to show. So you have to take this ground in your pleading so that they can file an objection and discharge the burden. Now suppose, but you have already argued from the case diary. So if you say that you have to file an objection, I'll give you time. But otherwise, it's up to you.
Result will be the same.
It's up to
Objection,
you.
Lordship. It's for them, Lordship, to bring it on record.
No,
Lordship.
no,
Lordship.
they have argued. His argument, now they have urged. It is, this matter cannot be now,
I cannot go, I will not go into this.
correct.
technicalities,
If
Lordship.
you want to take that objection, you want to file an objection, this court is ready to give you the,
Of no use, Lordship, I can understand.
that is
Lordship.
why I'm saying, that is why I'm saying, that is why I'm saying.
I cannot improve the case. What
That is
there
why
is
I'm
there,
saying.
Lordship.
So in a given situation, absolutely, Mr. Sharma, you are doing the right thing. You have to be fair to the court.
Yes.
You are ultimately an APP, right? So good, but anyway, it too. But yeah, I'm going to get the headache this look. Where are the records?
It's this one. Yes, Lordship. But flag must be noticed.
All right, Mr. This is item number
12, my lord.
12.
Item 12 লবা দেই first. Heard Mr. M. Nath, learned senior counsel, assisted by Mr. D.P. Borg, learned counsels for the petitioner. Also heard Mr. B. Sharma, learned APP for the state respondent. This is an application under section 483 of the BNSS 2023 seeking grant of bail to the petitioner, i.e. Papu Das, who was arrested on 19/12/2024 in connection with Kanpur PS case number 161 of 2024. Registered under section 61(2)(123 of BNS 2023, read with section 20C of the NDPS Act. Read with
20C/29, my learned friend missed it, my lord. Oblique 29.
20C/29
yes, there.
of NDPS Act, read with section 4(5) of Assam Bhang and Ganja Prohibition Act 1958. Stop. The brief facts of the case is that paragraph 3. Paragraph 3 and accordingly, a case was registered. Thereafter, a case was registered, and the petitioner was thereafter the case was registered, and the petitioner was forwarded to the jurisdictional chief judicial magistrate, and since then has been lying in judicial custody since since about
4 months, 12 days.
4 months,
12 days.
since approx 4 months, 12 days. Stop. Mr. M. Accordingly, the so is being filed. Mr. M. Not a paragraph 4 to Luba, a judgment to Luluba. Application 5. Paragraph 4, paragraph 5, paragraph 4 खाली ticket और नाम दीजिएगा. Paragraph 5 और B Sharma. Okay. Per contra, Mr. B Sharma led APP Assam by vehemently opposing the prayer of bail, submits that the notice issued under section 47 of BNSS, right?
Yes.
BNSS indicates that information as regards ground of arrest has been informed to the petitioner at the time via this notice at the time of his arrest. Stop. Paragraph 6 to Yapra.
Yes, Lordship, the FSL report is still awaited regarding the contraband.
How does it matter? We are not on the merit.
No, not on the merit, Lordship.
Even in fact, if you see in one paragraph, Bihan Kumar, I think para 17, the question of subsequently arresting is kept open.
Yes.
That is open. You see, I am not disposing. If you want, then it will be a different thing. I am not right now granting bail because of by going into the merit. Only reason I am bound to give, I have no choice but to grant bail is for non-compliance of Article 22(1). Because when Article 22(1) is established violation, court has no choice. That's all. Subsequently, whether you can re-arrest the person by giving the grounds, by following 22(1) or not, these are questions which are still open. Yes. Para 7 to aku likhiba, huh? Para 7. Para 8 or perusal of the aforesaid. First tak likhiba. Likhiba. Section 50 NSS Koba, which reads as under Hoboto Hikon a Yat Power 47 to Moira RDs records of power. Okay. Perusal, to tend to perusal of the aforesaid notice indicates that no particulars of the offense alleged, no particulars of the offense alleged no basic facts, no facts whatsoever constituting the grounds of arrest is reflected in the said notice. Rather, what it contains is that the petitioner is that the investigating officer has informed the petitioner that in course of investigation, since sufficient evidence was collected against him, he has been arrested in connection with the case under reference. It further appears that stop. That apart, where are the arrest memo and have you flagged it? It's not there. You are, this is Papu. This is Papu Das, na?
Yes.
Next paragraph. Pray likhiba, but court portion to yat koriba. My arrest memo. Okay. And paragraph 12 remains the same. Okay. Remains the same. Inspection memo. There was another person, Fazizul Khan.
I'm not following.
Memo. I have got the inspection memo. Riba. The argument, no, it appears that except it appears from the materials placed before this court that there are no materials available in the case diary to indicate that this is case diary to indicate that the grounds of arrest have been informed to the petitioner at the time of his arrest. It appears that in the notice issued under section 47 BNSS, what was communicated to the petitioner is that he was suspected to have committed an offense as regards the case under reference. That is not sufficient to infer that the grounds of arrest to infer that the fundamental right of the petitioner enshrined and guaranteed under the Article 22(1) of the Constitution of India is complied with. That apart, a perusal of the order dated 20/12/2024 of the jurisdictional magistrate, when the petitioner was immediately produced before the jurisdictional magistrate, you don't say that. Moreover, the case records does not indicate any contemporaneous record indicating the grounds of arrest were informed to the petitioner. 14 to Yarpani. 15. 50,000, 2 sureties, 15 to Sabah. Learned special judge? Mogao. Huh?
My lord,
This I'm keeping it. Yes, Rupa, case diary bhi likhit hoba etu koijo absent ghurai diba. Yes, you want to say something?
No, I just want to say, when I press for a bail petition normally, when I press for any bail petition, I never make a prayer. My lord, give
You
the bail.
never?
Pray that please give me the bail. What I do, my lord, personally I'm saying, my lord, I say this is the fact and therefore the records. Lordship, kindly consider whether I'm entitled or not. If I'm entitled,
Whether
I'm entitled or not.
no, but that is all right. But you see,
right,
when one urges that some procedure or some constitutional right is not complied, they have to be given that opportunity,
I'm
right?
not saying that.
So
Yes.
then, because that is, if I have understood Vihan Kumar correctly, you have that right, but you have to plead it somewhere. You have to give them an opportunity.
Opportunity,
I am
that's
not on
right.
technical points. I am not that you have not taken it in the writ petition, therefore I will not allow it. It's a constitutional right.
Mandate,
Let us not
mandate.
get into
It's a mandate.
technicalities.
Yes,
But
yes.
an opportunity must be given
That's
to be
what.
fair to the
Yes,
prosecution,
yes,
isn't
yes.
it?
That's why lordship asked him whether he wanted to
Correct,
leave it.
correct.
But he
So
was
see,
fair enough.
He was fair enough. That is
Yes.
why I said.
That's what. Yes, that's why I also thank him, my lord.
Correct. Mr. Shekhar, Mr. Rahman, I'm afraid you'll have to wait for the second half.
Yes, ma'am.
Miss Kumari, have you gone through or not? So be prepared.
I'm sorry, my lord, when the matter was called for,
CD available, madam.
Yes, Mr. Abdullah. What is this?
my lord, this is an application under section 482 of the BNSS, your lordship.
Hmm.
Actually, the crux of the matter is that, my lord, my wife, my lord, my earlier wife, she lost the case against me, my lord. her own volition, my lord. She has sent me a divorce sort of thing, my lord. She
Send you a
notarized, my lord, a talaknama, my lord. She has sent her own volition. When I was in Kerala, she has sent a talaknama. She on her own volition went, my lord. She married another person, my lord. Yeah, and the child also.
obligation, 376.
No. I'm the husband, my lord. The child also she has handed over to me, my lord. She has married another person now, my lord. Then some differences cropped out between the new husband and her, my lord. The new husband also left her. Now she is alleging that I have uploaded some private moments when we were married, my lord. This is the allegation, my lord. But she has gone, my lord, long back, my lord. She has married, and that is the from the FIR itself. It reveals FIR at page 9. FIR at page 9. The Talaknama, my lord, at page 16, my lord. She has only forwarded me, my lord. She has forwarded me the Talaknama. Is valid or not, my lord? I don't know, my lord. It's notarized, my lord.
Giving you.
Lordship.
Raj Malad, yes, she on her own volition Malad left her husband
Interrogation.
and Malad marry another person. Subsequently, Malad, this person uploaded 6 numbers of photographs, Malad, and police sees screenshots of those photographs where.
I'm not convicting him. Mr.
Yes,
Panch.
Malad. Those become viral. And because of that, Malad, now she stated that because of this uploaded of the
Our
photographs,
conjugal life.
second marriage, Malad, that
Yes,
is
but
also.
for that, should we put him inside the bar now? Tomorrow, the trial, whatever happens, he has to face it. All right, Mr. A. Huh?
SM Abdullah.
SM. Suddenly, I was wondering what was the middle initial.
Lordship.
SM Abdullah, after passing so many orders,
Lordship.
you know, at
Yes,
certain
Lordship.
time, you go blank, especially when
I can understand.
initials. SM Abdullah, learned counsel appearing for the petitioner, also heard Mr. K.K. Parashar, learned APP for the state respondent. You are not on Interium, na?
No, man.
By this application under section 482 of the BNSS 2023, the petitioner is seeking pre-arrest bail to the accused petitioner, i.e. MD Zakir Hussain, who is apprehending arrest in connection with Moira Bari Police Station case number 181/2024, registered under section 61(2)/74/79 of the BNSS 2023, registered under section 67A of the Information Technology Act. Stop. Anything is missed out here?
No, man.
The brief facts of the case is that paragraph 2. Facts of the case is that on so and so. Page 3. Mr. So and so learned counsel for the bail application. Next panel, Mr. So and so learned counsel for the petitioner submits that the petitioner is no way involved in the case as stated in the FIR and he further submits that the petitioner was married with the informant and was living happily. However, later on, she was in a relationship with one Tafazul Islam and therefore left him and also sent talaknama. However, after that marriage having been fallen apart, she has falsely falsely lodged the present FIR. Stop. Okay. Per contra, Mr. K.K. Parashar, learned APP for the state respondent, submits that it appears from the submits that the case diary is available. That it appears from the case diary that certain photographs of the
Photographs of the victim.
obscene photographs,
Option.
certain obscene photographs of the informant has been uploaded in the social media by the petitioner, and the snapshot or what you said, screenshots
of
those photographs were
seized by the police.
Seized by the police by the investigating officer from the mobile handset of the petitioner. I have heard and all that, but these materials available in the CD. Then you write. It appears that the petitioner has uploaded obscene photographs of the petitioner of the informant in social media. It further appears that the present FIR has been filed after the marriage of the petitioner after almost how many years?
6 years.
After almost 6 years since the marriage of the petitioner and the informant had dissolved. It further appears that after the said marriage having been dissolved with the petitioner, the informant had married another person. However, that marriage has also in the meantime dissolved. Stop. Be there as it may, this court is not adjudicating. This court is not conducting a trial, not trial, and is merely considering whether to grant pre-arrest bail to the petitioner or not. It appears that there is nothing adverse criminal antecedent available in the materials available in the case diary. That apart, there is no apprehension brought to the notice of this court as regards the petitioner fleeing from justice. In view of the efforts, considering the totality of the facts and circumstances of the case, this court is of the considered view that custodial interrogation of the petitioner may not be justified. Anything else to add? I think that is sufficient. And you're right. Accordingly, it is provided in the event of arrest, pre-arrest bail. How much?
10 days, ma'am. 10.
Arresting authority is 7-day conditions.
I'm deeply obliged, ma'am.
Only one thing, Malad, regarding seized, Malad, screenshots were seized on being produced by the informant, Malad, not from the mobile of the petitioner. On being produced by the informant.
That is vital. Then nothing has been taken from
him, Malad.
Malad,
she gave, Malad, it was uploaded. No.
It appears that the screenshots of the photos alleged to have been uploaded by the petitioner has been seized from the
on being produced by the
has been seized on being produced by the informant herself.
Obliged, Your Lord.
I know probably recall. Yes. Yes, Ms. Kumari. First, give this Mr. Shekhar, your case is 1100.
Yes.
First and foremost, what is the allegation against this particular petitioner? Because as far as the other case is concerned, I think that is about sharing the video.
Sharing
That
the
is the allegation, right?
Yes,
But what
Yes, sir.
about this petitioner?
it's a gang rape.
No, no, I understand. What is the allegation or what is there against this particular petitioner on the basis of which he was
There was
arrested?
nothing in particular.
The basis of the complaint.
Is the petitioner named in that complaint?
No, my lord.
It is
Shekhar,
not
please
there.
take your seat. He is not named. I understand. I have the entire second half for you. You can argue patiently, but first just clear the doubts of the court.
Nothing.
Yes, then
Memo of arrest given where he has signature and produced before the magistrate. Application for the remand, the reason has been given.
that is in the application.
Application
But in the
remand,
order of
in the order also, it is there.
what is there?
In the accused person, ground of his arrest are known to the accused person, no complaint is made by the accused.
Anything else you want to show from there?
And this is the petition filed by the then IO state police, where the reason has been given.
So in the case diary, the ground of arrest exists.
Ground of arrest in the order exists.
So in the case diary, in the
In
order
petition it is given. In petition
that
for
I understood, that is the petition which the IO has sent to the court of magistrate,
taking
court,
remand.
correct?
Correct.
Now that apart in the
memo of arrest, his signature is there.
there nothing mentioned,
Nothing else.
no particulars
nothing.
mentioned.
On the basis of the complaint
When was he arrested?
on 27, 23,
20 7
23,
23.
2023.
And when was he produced?
21st,
Next day,
next day,
25,
21st.
21 7 23, na?
Yes, Your Lordship. Then apart from that, again, for Kiran, other case, the same petition is there, arrest memo is there, they have acknowledged.
So this arrest was prior to Pankaj Bansal's case.
Yes,
Correct.
Pankaj Bansal. So the-
It's correct, I think, no?
yeah.
Prior to Bansal's case,
yes.
where because I think the requirement of in giving it in writing first came in Pankaj Bansal, correct? Which in Aurora it has been stated that that is prospective. So now one thing which is coming in the mind of this court is whether when the judicial order, when the judicial magistrate's order at the time of producing the arrestee on the next date, Mr. Raman, Mr. Shekhar, please hear it out.
Yes.
Whether that would also be sufficient because the requirement prior to Bansal is what is given cleanly in Article 22(1). That as near as may be, he has to be informed. Now, if the magistrate's order reflects that the grounds of arrest was informed,
Yes.
will that be sufficient?
No, my lord. That will not be sufficient.
That's what I'm asking you. You both will have to show that. That is one thing. And otherwise, this ground you have not taken in your petition,
I have
right?
taken the ground.
You have not taken. That it was that Article 22(1) ground
No, I've taken that
in your
para,
petition?
in my petition, I've taken the para 17, my lord.
Yes, sir. To that they had replied that which
Yes,
you had
my lord.
told me, right? Yes, ma'am. I'll come back. You both will have a right to reply. So I'm just expressing my thoughts so that you both are prepared. Yes, Miss
To that effect, they have.
That's okay. Now these are there.
Complaint itself is the ground of arrest. It becomes the ground of arrest.
Complaint means?
There is no complaint, no arrest.
Complaint means? So the FIR has been given to the petitioner. When?
Memo of arrest is given.
That's what, in the memo of arrest.
But it reflects that on the basis of the complaint, they are
But you
arrested.
see, Miss Counsel, you were a little bit on the track. Now don't get it, don't travel outside the track, because then you are in danger. You see, memo of arrest simply says as per FIR. That is not sufficient. FIR copy is not given. So when you look in the memo of arrest, the notice, nothing, no particulars mentioned. Vihan Kumar will come. He has to be given all these particulars. Correct? That is not there.
Yesterday, I have an effort to take out one judgment.
Of Bombay High Court, when
Yes.
Vihan Kumar is there, apex court judgment, what do you have to, how do you
Yes,
distinguish
that
that?
is why again it is agitated in the Supreme Court. The matter was heard on this issue only, and it is kept for judgment.
How can you argue that, Ms. Kumari?
So
It's
that
just
I
a-
have
it's a
also take out
constitutional right for-
take out the print. That is a Mihir Sa. Mihir Sa, that is a BMW case, Your Lordship, and it has been written in the.
Wait, have you given a copy?
Yes, the last one. Now, is available. In the last paragraph, it has been appreciated.
Now, you already, the investigation is going on. Anything you have found against the petitioner? Any materials, adverse material against the petitioner? What is that is why I'm asking repeatedly, what is the role attributed to the petitioner in bail application 1100/2025? In the other one, the allegation is that he has shared video. Then there are records to show that he has communicated with few of those persons.
Allegations are there. Victim has identified.
Those materials are there.
Those materials are there. I have made the check.
Sure.
Coming to this judgment, Your Lordship.
Yes, please.
Last page, last.
Yes.
Second, last but second paragraph. While
Yes.
we balance the right of the accused which have been on the parameter of life and liberty as in.
Where are you reading?
Last page of the Mihir Sa case, criminal petition.
Yes, I have made. Last page is para 7.
It is a bulk, next one. Other one.
Yes.
It is having number of pages, not.
This is Mihir Rajesh Shah.
That is different. It is reserved. Another one.
Where is it? That's not given. These are list of relevant document statements, CBI.
Even two.
Oh, sorry. Yes.
While we balance the right of the accused, which have been waived on the parameter of life and liberty as enshrined, we are of the firm view that the right of the victim will also have to be tested on the same parameter of Article 20, which guarantees the right to life and liberty and is equally applicable to the victim of the crime before us. In the light of the aforesaid discussion, we do not find merit in the petition praying that their release on the ground of illegal arrest as ground of arrest were not communicated to them.
Here, illegal arrest is on what ground? What is
That is the ground of arrest has not.
no is a violation of Article 22(1) established in the facts of this case?
Yes, Your Lord.
Let's see that. Because you see, there could be two situations. It could be 50 CRPC or 47 BNSS. That is different. What about Article 22(1)?
Yes, it is at page number 8.
Page number 8. Yes.
Both the petitioner therefore seek relief of declaration of their gross violation of the fundamental guaranteed under Article. Also seek declaration for setting a passed by the judicial.
Alright, that is the ground. Now, where is the finding of the court that there is a violation or there is no violation?
It is finding it will. We must, however, note that the magistrate clearly concluded that since the charge faced by
20?
the is 23, these are the findings coming from
3. Because if I am not wrong, perhaps in this case, the accused was caught red-handed. Perhaps. Page?
23.
Yes.
We must, however, note that the magistrate clearly concluded that Rajesh Shah was under section. He was accused of causing disappearance. Since it was a bailable offense, there was no reason for grant of his. Rajeshri is concerned, the magistrate recorded his conclusion as under. So far as the role of the shows that accused number 2 role in the offense punished. Initially, Mihir Shah was driving the said the lady about 1.5 kilometers, but at one point of time they had interchanged the seat and the accused number 2 the vehicle on the body of the lady. It is contended that they have CCTV footage to that regard. I own the mobile in the was stored. It is not clear from the footage who was the driving the vehicle. That time when vehicle rammed over the body of the it was a Mihir or present accused number 2 who allegedly shifted to the seat at that moment. On this aspect, investigating officer has case paper, particularly statement of admitted that he had shifted to the driver's seat that moment. So prima facie, there appears role of accused number 2.
That is why I'm saying this decision may not be of help. Come to para 20. It is in this background when we appreciate the pleading raised in the petition about the grounds of arrest not being communicated. We must record that both the petitioners are conscious of their serious act of hitting the mob driven by complainant by the BMW car which was being driven by Mihir Shah with so-and-so sitting next to the driving seat and the car being driven in a rash and negligent manner with Mihir having consumed alcohol when the so-and-so. So here they are trying to infer, and I'm sorry, but I don't share the same perception. Judgment of the Bombay High Court can be of persuasive value only. I don't share the same perception. It cannot, you see,
victim's right has to be also
I understand, but you see the constitutional right cannot be tinkered, cannot be inferred. And in your case, there is nothing in the complaint showing that he was, his name is there. It says some mob. Whether he had conscious knowledge, nothing is discardable.
Identified them.
Huh?
Victims have
That is
identified.
later. Not at the time of arrest. Correct
They
or
are
not?
not in a position to come. They are not allowed
See,
to come in their house.
That
also.
is why, Miss Counsel, why couldn't the investigating officer simply inform the arrestee that because of such and such event, we suspect that you are part of the mob and we are arresting? What prevented the investigating officer to simply give this information to the arrestee? Is this some sensitive information? Is it some sensitive information that it cannot be shared? I understand that the offense is grave. That doesn't mandate the concerned investigating officer to ensure that all the procedures are followed? Now you don't follow those procedures. And then you want this constitutional court to ignore the constitutional and fundamental rights guaranteed to the citizens. You see, you understand the difficulty or not? And the fact that I am hearing this matter for so long is because in my conscience, even I don't want to grant the bail, but I'm in a very...
Because of this technical glitch.
I'm trying to find out an option. The decision is very clear. It's a
But on the
constitutional
very
right.
next day, here reason has been given. In the very next day, when this petition is filed before the magistrate, the state police has given the reason.
Show me that.
This is.
Investigation officers must be
This is
taking
one of
their job seriously. They should not be doing it in
This
this
is one of the
fashion.
reason, that is why it is transferred to the CBI and thereafter
It is not only there, everywhere.
everywhere.
If you have been sitting in this court since morning, you must have
I
seen
have seen every time this problem is coming, this
Going on.
technical glitches.
Let us not generalize a particular state. It is going on. That's not right. And then to come before the court and show the graveness of the offense. If the offense is as grave, isn't it more the requirement of the investigating officer to ensure that all the essential safeguards, the protections, procedures are followed, given? Is it not?
Other side has to also be weighed in the same test, like
Others-
victims.
Your Ms. Counsel,
Agony has
please,
also to be
you see,
tested
repeating
on.
your submissions will not get you anything. Don't repeat that. Don't play the victim card right now. First and foremost, it is
Procedure has to be followed.
Correct.
That procedure established by law has to
correct.
be followed.
You please, I understand. I understand that. I have full empathy with the victims here, but that alone will not be sufficient. And in Mihir Rajesh Shah's case, there that fax was there. He was driving the car when the accident had occurred. So when he was arrested, he knows why he has been arrested. Here, nothing like this happened on the first day. Later on, it has come. There's nothing on record to show. Anyway,
Later on complete.
what is this document?
This is the application filed by the then IO for remand of the
Where is the order?
order in the later on the ground.
Round of arrest of A6. Who's A6? Are we concerned with A6? Kiran.
Mr. Kiran.
Are we concerned?
I'm the Kiran
In
is
your case.
yes, Your Lordship.
And number 2 is 9.
Arun Khandang.
Arun?
Your Lordship, the mic is not audible. Your Lordship, the mic is not audible. Your Worship, the mic is not audible. Yes, sir. Your Worship, I can't hear. It's not audible, Your Worship. That.
Six. I have annexed the copy of the search sheet also. It is 16.14. Among the mob, victim 1 identified accused Arun Kondongbam, A2, who took active part in the same incident. Physical assault.
Which page?
Page 106,
Yeah.
last three lines,
Page 106.
last three lines.
Mr. Raman, are you being able to hear us?
Yes, Your Lordship, I can hear.
Now?
Charge sheet 106 page.
This is one sentence against the present accused, and there is one more sentence in the entire search sheet that is page 111. 111.
Okay.
Yes. Allegation is that you have actively taken part.
Yeah,
That
he
is
was
the
a part- that is the only allegation. He was the part of
What
the mob.
role you have
No,
done?
nothing has been
Nothing has
described in the search sheet also. Here in 1111, it says victim 3 has identified accused Arun Kundangbam and lawyer absconding at present are from among the mob. That is the only sentence, two sentences.
Any Miss
No
Ari,
accusation activity.
anything from the case diary or from the case records, from the statements that have been
Yes.
recorded,
160, yes.
has anybody ascribed any particular role against the petitioner?
Victim's statement.
No, victim has the victim said that victim has generally said that yes, he is one of the person in the mob, right? That's all. But what is the role played by the accused? Is that mentioned anything?
I'm going through the 164 statement of the
Go
victim.
through by now. You should have gone through. So one thing which is an admitted position, yes, Ms. Maji, right? Ms. Maji, from the case diary, one thing which appears is that in the case diary, there is nothing to show that the accused was informed as regards the ground of arrest. That is an admitted position, isn't it? Now, what appears is that the investigating officer, while forwarding the petitioner before for appearance before the jurisdictional magistrate court, in that petition, the grounds of arrest is mentioned. Right? But there is nothing otherwise. And the judicial magistrate's order simply says, in respect of the first bail application, that the grounds of arrest was made known.
With respect to
Correct. But nothing is there to show otherwise.
right.
The difficulty, you understand?
Not only 164 and photo identification is there. She has identified the accused. They were the clearly written, my nephew was killed just like my brother. And thereafter they dragged the ladies and stripped them forcefully, made a video of them, pleaded them naked, paraded them naked. A video of them touching their private parts, continuing shouting and their, in fact, cheering and mocking at them. I recognized one guy paraded over the ladies. His name is Arun.
So this was during 164.
160.
After this, he was arrested. Or before
Yes,
this?
Before that.
Before that.
Before that. Thereafter, identification has come when they are in custody.
Correct.
And 164 has been taken of the
That
victim.
is why trying to see even if I can do something which the Bombay High Court have done.
Has categorically identified Arun in
At the time of the arrest, why this was not done? Mr. Shekhar, you have Vihan Kumar.
Yes, madam.
Para 17, what according to you, para 17 would mean?
That part is still open.
What does it mean?
Another argument canvassed on behalf of the respondents is that even if the applicant is released on the grounds of violating Article 22, the first respondent can arrest them again. At this stage, it is not necessary to decide the issue.
That was kept open.
That has been
Kept open.
Yes, madam.
That is kept open. Can I re-arrest him?
ground.
See, Mr. Shekhar, you understand because
Okay, wait.
Morally, there is some difficulty on the
Very
part of
only
morally.
that. Otherwise, if you have noticed, I have seen you in this court since last two days, perhaps. So many matters have been coming before this court where Article 22(1) has been violated.
Yes, my lord.
It didn't took me a second to allow those. But when I am faced with the facts of this case, allegations are absolutely heinous. Of course, I'm not convicting, but
Yes, my lord.
you see,
Apparently, allegations are heinous.
yeah,
Even then, the
and trial is going on, perhaps
not yet started.
trial
Trial
is
has
not
not-
started.
Not yet
It is
started.
started, sanction has come for 153A recently only, and the cognizance is
Yes,
Also,
what do
going to
you,
be taken.
what do you want to say?
Already, lots of they are in custody for almost 2 years, my lord.
Years in your case.
Yes, my lord. Almost 2 years. July they will complete 2 years, and maximum punishment is 10 years if at all they are convicted. That is the maximum.
Yes.
As because their fundamental rights have been violated, all other things will come later on. That part will have to be satisfied for us. On ground alone, I am entitled.
Yes, Mr. Raman.
Yes, Your Lordship. Your Lordship, with regard to my client, Your Lordship, I was not arrested, Your Lordship. I was
You had been called, and when you went, they arrested you.
yes, Your Lordship. I was restrained, and I was restrained on 24th of July 2020 with a and
In
the
your
charge.
case, you have been, it's on second case too, filed. I think you have mentioned it in that note.
किरण का भी तो होता है identification. हाँ, निकाल लेंगे. 164.
You have been arrested on
24th July 2023.
your is your is bail application number
1169 of 2023.
169.
Yes, sir. And Your Lordship, I have been in custody for more than about 644 days as on date.
164.
And the allegation against me is that I have shared the video clip which has been made. I have received from one Pukhrambam Suranjoy, and I have shared it on the social media, which they have stated in their affidavit also. In their objection also,
As far as your case is concerned, the allegations, as far as you are concerned, this is about sharing the video. It is not that you were part of the mob.
no, Your Lordship. The only thing is that I have shared the video through that also on the social media. However, Your Lordship, from the day of the occurrence of the violence, the ethnic conflict on 4th of May, the Commissioner of Home Government of Manipur issued the order, thereby suspending all the
When
mobile.
were you arrested?
I was in the
July.
When?
I was arrested on 24th July
24, 7.
7, 2023.
किरण का तो ground दिया हुआ है.
And Your Lordship, the only allegation is that I have shared the video on social media. However, the internet, mobile data, as well as broadband has been under suspension from 4th May 2023.
All right,
During-
these factual aspects you've already argued yesterday, and it's there in your notes.
Yes, Your Lordship.
What do you have to say about the Bombay High Court decision, which has been relied by the other side?
The Bombay High Court decision, Your Lordship, before that we have this, it has been, I think, superseded by the Vihan Kumar judgment, Your Lordship. And the Vihan Kumar judgment have strongly relied upon the Pankaj Bansal. Pankaj Bansal judgment, Your Lordship, it has been reported in 2024, volume 7 SEC, page number 576. And Your Lordship, in this, Your Lordship, Pankaj Bansal judgment, Your Lordship, this has been again followed in the Vihan Kumar, where they have
So
stated that
because one thing is right, Ms. Kumari has placed the decision of the apex court wherein the decision of the Bombay High Court was assailed. Now their paragraph 3, if I shall read it out for both of you to just react.
Yes, sir.
The question that we are called upon for consideration in the present proceedings is whether in each and every case, even arising out of an offense under IPC, would it be necessary to furnish grounds of arrest to an accused either before arrest or forthwith after arrest? Another question that this court is required to consider is whether even in exceptional cases where on account of certain exigencies, it will not be possible to furnish the grounds of arrest either before arrest or immediately after arrest. The arrest would be vitiated on the grounds of non-compliance with the provisions of section 50 of the grounds of non-compliance with the provision of section 50 of the code of so and so. Hearing concluded, judgment reserved. So this judgment appears to have been reserved.
Yes,
Now,
Your Lordship.
undoubtedly, here we are faced with an exceptional case that there cannot be any.
In that case, Lordship, I have one judgment. Right now, I do not have, where it says that if the judgment is reserved or something like that, then nothing doing. Whatever is already there, what is the law, that has to be followed. Till that other judgment comes. I can
No,
share
the
it with
only
you, Lordship.
difficulty is in Vihan Kumar, it was not an exceptional case. Not in the context of an exceptional. Here, at the end of the day, it is also the discretion of the court. Grant bail or not to grant bail. Correct. And each case has to be considered in the facts of that case. Now here, this court is faced with a very exceptional situation. So whether can it be, say, in fact, in your case, it appears that forthwith from that order of the judicial magistrate, it appears he knows. The following.
It reflects only in the order.
Correct. So that is sufficient for this court to accept. That is sufficient, Mr. Shekhar.
Your Lordship,
Anyway, what about the second case? Where is the order? When can you have it?
We will have to collect from the trial court.
When? Monday? Friday? This Friday?
We'll try for Friday. Today is the
Give
Wednesday.
that order. Otherwise, prima facie, I am of the opinion, Mr. Shekhar, that as far as your case is concerned, it looks that thereafter there is some materials to indicate that the petitioner was informed. Okay. I am only telling you prima facie so that you, if you want to give a rebuttal to that, you can. However, as of now, it appears that when it comes to the second case, there is nothing on record. There is nothing on record. Unless you give us the order on Friday.
We'll try our
indicating-
best to search if I'll get something in the order of the magistrate court on the, and usually they give the further demand.
Sending the petition is not sufficient.
So order.
Order is needed.
Okay.
Because today there was another case where the order was, the grounds of arrest was mentioned, but in the order, it is not reflected. That's why I granted. It has to be there in the order,
They're
you
there
see.
in the order.
Because
That is a-
otherwise mere existence of grounds of arrest will not do.
Not do. It has to.
It has to be informed. Now, in the case of Mr. Shekhar, it appears that the magistrate court records a finding to that effect. That finding has not been challenged. There is a finding that the grounds of court can always, on that basis, take an opinion that yes, it has been complied. Isn't it?
I'll reply to that.
You reply. That is why I'm not disposing. Otherwise, I could have rejected your bill right away, but I have not done that, Mr. Shekhar. I'm giving you that much time. All right. You have a look. And in the second case, you please give us that order.
Okay. We'll try to collect by Friday.
You have to go back or you're going to be here till Friday.
You will have to be stay back. He has already cancelled her ticket yesterday.
You enjoy the weather of Guwahati, huh?
Friday means second.
Your Worship,
Monday को कर लो.
Your Worship, with regard to the Kiran, the allegation about the video here, that is the only allegation.
I understood. I understood.
Now, Your Worship, the charge sheet, even if we keep aside the Article 2, Clause 1, we keep aside.
Council, let us see what is the position. If tomorrow the position comes that in your case also there is an order showing the grounds have been informed, then you can urge these points. Because
Yes, sir.
if suppose in your case that is not there, then
Yes,
there
sir.
is no need for all this.
Yes,
Because
sir.
you see, you both were not arrested on the same day.
No, Your Worship.
They have not been also produced on the same day.
Yes,
So
Your
you
Worship.
don't know what is that is why I am not hurriedly reaching any decision at this moment.
Yes, Your Worship. Yes, sir.
But there cannot be an escape that the balance, both sides the stakes are very high. Have to strike a balance somewhere.
Yes, sir.
This is the case records which you have given today. I think it's better you keep it.
Okay, thanks.
I'm returning whatever is here to you, huh?
Yes, Lords.
In the first item, you say heard Mr. R. Shekhar, Learned Counsel for the petitioner, also heard MSM Kumari, Learned Special Tending Counsel as a CBI.
Retainer counsel.
Retainer counsel. Pursuant to this court's order dated 9/4/2025. Pursuant to this court's order dated 29/4/2025, the case diary has been made available before this court by MS Jyotirmoy Maji, the concerned investigating officer. A perusal of the case diary indicates that that after the petitioner was arrested on 27/2023, the was produced before the jurisdictional magistrate court, and the magistrate court, while that was while directing remand, that is the order. While remanding the petitioner by order dated 21/7/2023, observed in the remand order date that the grounds of arrest has been informed to the petitioner. Stop. However, in the connected bail application 1169 of 2025.
This is in respect of Kiran.
Which one? A judicial order?
Yes, yes.
Is
Yes,
it?
Yes, it is in respect of Kiran.
Kiran is a which case?
The other one.
Other one.
Not Mr.
What?
Shekhar's case.
No. He's Arun.
Huh?
He's Arun.
Then and again but instead of bail application 1100, you make it bail application number 1169 of 20.
This is good.
Raman, your initials?
Pardon, Your Worship.
Your initials?
Juno Rahman, Your Worship.
Sorry?
Juno Rahman.
J.
Yes, Your Worship. J. Rahman.
J. Raman. J. Raman. Huh? Okay. The question, therefore, that arises for claim is sufficient to to infer and to hold that the petitioner had the requisite petitioner was the petitioner sufficient enough to hold that the petitioner was informed as regards the ground of arrest. Stop. List for further hearing on such and such date. And in the second case, 1100, first dot naam to hubo R Shekhar. Any middle initial arrow same type of case diary produced kora to koba. However, the judicial or however the remand order of the jurisdictional magistrate is not available in the case diary. MS
Only application is available. Order is not available.
I need the order.
Correct.
Order is important. How do we know this? Have you given the copy of the application to the petitioner? We given. Then what? Accordingly, 6 days time. 1 day time to copy of the remand order. Prayer is allowed. List on Friday.
Friday.
On Raman, I hope you have understood that remand order exists in your case, not in Mr.
Yes, Your Lordship. Your Lordship, in that case, I have to argue for on the other merits also, Your Lordship.
Yes.
Your
Friday.
Lordship, yes, sir. Even in the Vihan Kumar's, they said merely.
Sorry, your voice is breaking. I cannot hear you. Yes, what were you saying about Vihan Kumar?
Your Lordship, in the Vihan Kumar judgment, Your Lordship, it has been stated that merely mentioning that the grounds of arrest have been made. That is not.
No. There is a difference. You are referring to para 18 and that subsequent paragraph. You see, there the contention was that there is an entry in the case diary that it was informed. Now that is an entry concerning the case diary, correct?
Yes,
now
Lordship.
here the magistrate court, while remanding the accused, has observed that the grounds of arrest were informed to the petitioner. So therefore, that now this court cannot overlook that. That is sufficient for this court to assume that yes, the grounds of arrest was given.
Yes, Your Lordship.
Because it's a magistrate court's order. It is not an entry in the case diary. Because till there was no requirement to show till then at the time of your arrest that this has to be communicated in writing. As of course under the CRPC those were there, but Constitution they are talking about the constitutional safeguards.
Yes, Your Lordship.
Constitution simply did inform, which now have said that that information is meaningless until and unless it can be in writing.
Yes.
Henceforth, whatever arrest is made, it has to be communicated in writing.
Yes,
that is
sir.
perspective. Correct. I think
Yes, sir.
there is no quarrel.
Your Lordship, there is one more perspective, Your Lordship, because the reason for putting someone behind a bar is that because he may temper the evidence or he may incite the victims or witnesses. But in the present case,
Then
Your
now
Lordship,
you are improvising your grounds because the factual. So you mean to say that there is no apprehension that one may hamper or temper the because
only
video
against.
has already been seized. Correct.
Yes. And the investigation has already been completed because the CBI have filed a charge sheet. Now, when the charge sheet has been filed and the investigation has been.
I'll keep that in mind. Noted.
Yes, Your Lordship.
Ms. Kumari, please also inform on the next date. What's the current stage?
Yes.
Proceeding? When is
I'll proceed.
so you see, in case of Mr. Yes, no? 2 years.
Our concern is that the victim, if they are allowed to go on bail, the victim won't come to their house. And
Victim will not come to
their own house. They are residing outside.
Residing outside.
Victims.
Victims.
Yes.
Your Lordship, the
They
victims
are
are.
afraid of them.
are under the protection of the CBI, Your Lordship. They are under the protection of the
Always
uh,
security
This
is
is
the,
a photocopy,
yes,
photocopy.
it is photo.
So I'll keep it here.
That apart, there is every possibility of
Yep.
threatening may
All
be
right,
given
all
to the
right, all right.
witness.
I think for today, I've given you enough audience. By Friday, I will forget everything. So you save your energies for Friday now. All right.